This is day two of the evidentiary hearing in Veolia Water Delaware Inc., which is PSC docket number 25-0037, which is a water-based rate case filed by Veolia Water Delaware Inc. Prior to going on the record, the parties reached a number of agreements which limited a number of the issues that needed to be discussed this morning. But I'm going to turn to the company now, which has an issue that it wanted to raise this morning.
Yes, Your Honor. Thank you. Good morning. The company would like to make a motion for reconsideration of your decision yesterday to exclude the portion of Ms. Hatch's rebuttal testimony dealing with the PFAS O&M mechanism that was proposed in her rebuttal testimony. And specifically, I'm basing the motion on Your Honor's order number 8707 and docket number 14193. That's in the matter of the application of Delmarva Power. It continues, but I can certainly provide the full citation. In that proceeding, Your Honor denied a motion in limine to exclude portions of rebuttal testimony that presented a new theory for the first time. Your Honor specifically found, quote, "This commission has never distinguished as to which facts, arguments, or analysis must be included in direct and rebuttal testimony. The commission has never done this because it obviously wants to develop a complete evidentiary record in a constantly changing administrative case such as this, where the joint applicants must establish at the evidentiary hearings that this proposed merger is in accordance with the law for a proper purpose, and that proposed merger is in the public interest," end quote. Obviously, the facts are a little different here, but the rationale applies, Your Honor. Your Honor continued, quote, "The commission does not have a case-in-chief requirement requiring the joint applicants to, without recourse, stick with their direct or deposition testimony and not file rebuttal testimony. This is an administrative agency, not a civil court, where a cause of action must be proven or a litigant is subject to a motion for directed verdict, which must be raised prior to a defendant beginning to attempt to prove an affirmative defense. The method of presenting evidence in a civil court is much different than the method employed by the commission. The potential of rebuttal testimony abuse is much higher and has more impact in civil court when such abuse is virtually non-existent at the commission due to how the commission liberally permits evidence to be presented to the conclusion of the evidentiary hearings," end quote. Your Honor then continues to cite case law and says specifically, quote, "Delaware cases have uniformly held that if a party is given the opportunity for cross-examination of a witness's evidence submitted in rebuttal will not be excluded," and quote. Your Honor cites Tower View LLC versus Cox Radio Inc., 2013, Delaware Chancery Lexus 159, Delaware Chancery Court, June 28th, 2013. And there's also indicated that Your Honor cites additional cases that were cited by the applicants in that case. And therefore, Your Honor made the decision in that case to allow the rebuttal testimony, the new theory on rebuttal testimony, and allow cross-examination on that. And for those reasons, Your Honor, we would submit that Ms. Hatch's rebuttal testimony on the PFAS O&M mechanism be allowed, that staff and DPA be permitted to cross-examine her, and to the extent they wanted to have their own witness discuss that testimony on direct, we would have no objection to that.
Has the company provided that decision to staff and the DPA?
I have not. I can email it to them right now, Your Honor.
Okay.
Would Your Honor like a copy as well?
Staff?
Without having read the case, I can, just from Mr. Simon's description, it's different circumstances. That case was a merger. This case is a rate case hearing. Again, without having seen what he is referencing or considering the other case law cited in there, something that sticks out to me is that a lot of that was just a lot of what the quotes he was giving were discussing evidentiary issues. And I don't think that's what we're discussing, whether it's so much an evidentiary for admissibility, so much as whether it is permissible for the company to, instead of rebutting what is said in testimony, to say, well, we're not going to do that anymore. Here's a new thing we're going to do instead. So based on what you said in your direct, here's a new thing we're going to do instead. That adding to is not rebutting. So the purpose of the rebuttal testimony is to take what the direct testimony has said and say, no, you're wrong because. Whereas in this case, it seems as though in Ms. Hatch's rebuttal testimony, it's saying, well, if you're right, here's a different thing we should do. And the main problem with that is that this is a brand new idea that staff has not had an opportunity to evaluate, and to just expect staff to go above and beyond what we're expected to do in order to respond to this new information. Taking it to its furthest conclusion is that in rebuttal, could you bring up anything? Could you bring up anything new that you want to add to your case? Because that's kind of where this looks like it's going. Like, if we can just keep adding and adding in rebuttal, then what is the point of rebuttal if we can just keep adding and adding to it? And so obviously I would have a better response after reading the case law cited.
DPA.
Your Honor, given that the motion's just been presented this morning, we haven't had an opportunity to look at the case law. We'd respectfully ask that this matter be at least continued until the afternoon. In terms of this specific, I understand counsel's, he's bringing this in for reasons, but it's hard to respond when we haven't actually had a chance to look at the cases.
Just very briefly, Your Honor, and I know this was discussed yesterday, but I think, the motion to exclude Ms. Hatch's testimony should have been the subject of a pre-hearing motion. Obviously, if that had been dealt with before, this would be different circumstances, but I wanted to make the motion as quickly as possible based upon my research from last evening to today. So I do apologize for the timing, but obviously that was dictated by the events of yesterday. So
I understand. Okay, so let's just table it for now and give staff and the DPA and myself an opportunity to review what you've emailed us, and then we'll take it up at a later time.
Thank you, Your Honor.
Okay. So is the company prepared to call, I assume, Mr. Cosgrove?
Yes, the company is prepared to call Mr. Cosgrove. The company and staff have reached an agreement with respect to eliminating certain portions of Mr. Cosgrove's rebuttal testimony. And I am happy to read the affected portions into the record or identify what those portions are.
Okay, please do that.
The first portion The first portion, Your Honor, is going to be on page 5, and it continues on to page 6. It starts on line 18, and what will be eliminated is as follows. Also, a Delaware House Bill, parentheses, HB 8, end parentheses, required DENREC to establish state-level MCLs for PFOA, PFOA, and PFOS. The next portion is page 6, beginning at line 8, the language that reads, sampling was required beginning by the spring of 2023, and a single exceedance of more than twice the MCL would necessitate immediate response, possibly including provision of a temporary alternate water source or installation of treatment. The next portion begins on page 8, line 18, and reads in total, quote, notwithstanding this 5-year period, water utilities are required under the federal regulations to complete initial monitoring by 2027. And if their systems exceed the MCLs, they must notify their customers that their drinking water exceeds the levels that EPA has deemed safe. The next portion begins on page 9, line 10, and reads as follows. Therefore, even if EPA makes its PFAS MCLs less stringent, which there is no indication it intends to do for PFOS or PFOA, or eliminates some of the others, all 6 PFAS MCLs will remain in effect in Delaware unless Delaware changes its laws. It's law, not laws. The next portion is on page 11, line 13. And the only 2 words that will be eliminated from that line are the words "and regulatory." The next portion is on page 12, lines 8 through 9. The following words will be omitted. However, the Delaware law requires public reporting to begin in 2026, well in advance of federal regulations. The next portion begins on the bottom of page 12, line 23, and continues on to page 13. And it reads, "This means it will be an uphill battle for legal challenges to the PFOA and PFOS MCLs that seek less stringent limits." The next portion begins on page 14, line 21. The following language will be omitted. It is true that the company monitors PFAS monthly, which is 3 times more frequent than EPA's minimum quarterly requirement. However, I totally disagree with how witness Azad is evaluating necessary and appropriate PFAS testing. However, I totally disagree with how witness Azad is evaluating necessary and appropriate PFAS testing. She confuses what is required under the federal MCL rule for compliance monitoring, parentheses quarterly, and parentheses, with what is needed to operate a facility that is pilot testing for PFAS treatment or has recently installed PFAS treatment, parentheses, monthly as described by the company, and parentheses. The next portion is page 15, begins on line 15. The following will be omitted. And I would expect that DENREC and EPA would agree. The next portion begins on the bottom of page 15, line 22, continuing on to page 16. The following language will be omitted. The federal regulations and Delaware statutes effectively require that the treatment system reduce PFAS concentrations to 4 ppt, which is the level of detection established by EPA in 2023 when the rule was proposed. The next portion is page 17, lines 5 and 6. The following language will be omitted. However, consider that instead of completing quarterly monitoring, which is the minimum required by regulation. The next portion begins on page 18, line 22, and continues onto the following page. The following language will be omitted. It is my opinion that the company appropriately assessed the regulatory timeline for implementing its PFAS treatment plans during the period from 2016, when the EPA lowered its HA for PFOA and PFOS down to 70 ppt, to 2020, when other states, parentheses, e.g., NJ and NY, and parentheses, established PFOA and PFOS MCLs in the 10 to 14 ppt range to the 2021 release of the EPA PFAS Strategic Roadmap and Delaware proposed MCLs for PFOA and PFOS at 21 ppt and 14 ppt respectively, and concluding in 2022 with EPA lowering its HAs to below detection levels and Delaware announcing its intent to impose MCLs for PFOA and PFOS of 4 ppt. It it became crystal clear that PFAS regulations were becoming more stringent and that detectable concentrations in drinking water would not be accepted by the public or regulatory agencies. Next portion, page 19, beginning at line 18, the following language will be omitted. Based on the history of the regulations, parentheses, provided in the preceding paragraph and on pages 4 through 9 of my testimony, end parentheses, and my review and understanding of the timeline of actions taken by the company, parentheses, as I summarize below in this paragraph, end parentheses. The next portion, excuse me, that's the final portion. So that is the testimony that is going to be omitted from Mr. Cosgrove's rebuttal testimony, Your Honor. The company does not concede in any way that Mr. Cosgrove is not qualified to offer those opinions. Simply agreeing to remove those portions from the record.
Okay. So you're going to call Mr. Cosgrove now?
Yes, Your Honor. The company calls James Cosgrove as its next witness.
Good morning. I do.
Your Honor, I believe I already.
Yes, it was, it's Exhibit 11 marked for identification from yesterday.
Mr. Cosgrove, do you have a copy of Exhibit 11 that's been marked for identification as your rebuttal testimony in front of you?
Yes, I do.
And I believe I confirmed this with you yesterday, but you did prepare that rebuttal testimony, correct?
Yes, I did.
And you did identify one or two corrections in there, correct?
Yes, I identified 2 corrections.
Thank you. And you were in the hearing room today when I read out those portions of your testimony that are now omitted from your rebuttal testimony, correct?
Yes, I was.
And you heard and understood those omissions, correct?
Yes.
Thank you. Your Honor, at this point, I would move for what's been marked for identification as Exhibit 11 into evidence as Exhibit 11 with the modifications I previously noted this morning, Your Honor.
Staff, with the modifications, may Exhibit 11 be admitted into evidence?
No objection from staff.
DPA,
No objections from the DPA.
with the modifications, Exhibit 11 is admitted into evidence.
Thank you, Your Honor. I don't have any further questions for Mr. Cosgrove on direct.
Staff, Cross?
Of course. May I approach and
Yes.
pass out the documents? Morning, Mr. Cosgrove. Are you ready to get started?
Yes, I am.
On page 3 of your rebuttal testimony, you state that the purpose of my testimony is to respond to the testimony of witnesses Ava Azad and Ara Azad and the proposed disallowance of the Stanton Water Treatment Plant, SWTP, capital expenditures incurred by Veolia Water Delaware Incorporated for PFAS treatment, as well as proposed disallowance of the operation and maintenance costs incurred and to be incurred for that treatment system, correct?
Yes.
So to summarize, the purpose of your testimony is to respond to staff's expert's recommendation in this rate case, proceeding to disallow recovery of capital expenditures incurred by Veolia Water Delaware for PFAS treatment, and to disallow recovery of PFAS O&M expenses incurred after the test period, correct?
Yes.
Mr. Cosgrove, are you an accountant?
I am not.
Do you have an accounting degree or accounting certifications?
No, I do not.
Are you an expert on rate setting for regulated utilities?
No, I'm not.
Page 12 of your rebuttal testimony, at the very top, the presents the question, do you agree with witness Abba Azad's characterization of the state and federal regulations underpinning the company's obligations to treat for PFAS, correct?
Yes.
Mr. Cosgrove, are you an attorney?
Could I back up 1 second? I think I just answered your question wrong. Are you asking me whether I see that statement at the top of the page or whether I agree with it?
Whether you see it at the top of the page.
I do see it at the top of the page.
And that is what it says.
Correct.
Okay. And Mr. Cosgrove, are you an attorney?
I am not.
Do you have any formal education or credentials as a legal professional?
No.
And you filed rebuttal testimony in this case evaluating the, quote, characterization of the state and federal regulations, end quote, in the testimony of a witness who is a licensed attorney, has been practicing environmental law for over a decade, and was involved in the drafting of the PFAS regulations relevant to this rate proceeding, correct?
That is correct.
So returning to that question at the top of page 12, your response on lines 4 to 5 says, while witness Azad accurately states that EPA adopted a final PFAS MCL rule in April of 2024, she downplays or ignores the fact that the rule is currently effective. Is that correct?
Yes.
In preparing your rebuttal testimony, you reviewed Ms. Abba Azad's direct testimony, correct?
Yes, I did.
In front of you in that stack of documents should be a copy of Ms. Abba Azad's pre-filed direct testimony.
Yes, I have it.
On page 5, lines 17 through 19, her testimony states, first, regulated systems must meet sampling requirements, which are divided into 2 stages, initial monitoring, currently in effect, and compliance monitoring. Is that correct?
Yes.
Then in her testimony on page 6, lines 2 through 5, state that the surface water systems like Veolia Water Delaware are required to complete 4 quarterly samples within a 12-month period, 2 to 4 months apart, under the initial monitoring requirements currently in effect and potentially during compliance monitoring. Is that correct?
Yes.
And then on page 7, lines 4 to 5, given that the original rule was finalized and the effective date has passed, the EPA must go through a formal rulemaking process to make changes to the existing rules. Is that correct? That the statement is there.
Yes.
Going back to your rebuttal testimony, on page 12, lines 14 to 15, you state, Witness Ava Azad implies that PFAS MCLs may become more relaxed. It is unclear what the basis of this belief is. Is that correct?
Yes.
Referring to Ms. Ava Azad's pre-filed direct testimony, would you please read the portion beginning on page 6, line 19, ending in page 7, line 2? And you can read that to yourself.
Yes, I've read it.
So according to Ms. Azad's testimony that you just read, the EPA has announced plans to reduce the scope of its current PFAS regulations and extend by 2 years the compliance deadline for the drinking water standards that remain, correct?
They have announced that, but they have not taken any formal action. And
But that is what the testimony says, correct?
that is what the testimony says, yes.
Thank you. Now, would you please read Ms. Ava Azad's testimony from page 7, line 22 to page 8, line 5? And again, you can read that to yourself.
Before I do that, I just want to clarify something. The statement that you asked me to just read on the bottom of page 6 and the top of page 7 doesn't reference the fact that EPA indicated that they were not planning on changing the PFOA or the PFOS MCLs. May I just clarify something with you? You asked me to read the paragraph at the bottom of page 7. Is that correct?
Yes. And then to that paragraph and then the first question and answer on page 8. So that's page 7, line 22 to page 8, line 5.
Okay, I've read it.
Going back to the clarification that you just made before we read that little section, can you read page 6, line 19, which is the question, out loud for us?
Has EPA announced any planned changes to these PFAS regulations?
That is specifically answering whether or not there are planned changes, what we had just discussed. Is that correct?
That's correct.
Thank you. Now going back to those 2 questions and answers we just looked at on pages 7 and 8, have there been any legal challenges to the PFAS drinking water regulations? I apologize. I'm reading your words.
Objection. I believe you're reading Mrs. Odd's words, not Mr. Cosgrove's
Oh,
words.
apologies. According to Mrs. Odd's testimony, which we just read, the implications of the case American Water Works Association and Association of Metropolitan Water Agencies has the potential to force water regulations to be reduced, or as you put it, become more relaxed. Is that correct?
Are you asking me whether I agree with this, or are you asking me to confirm what it states?
I'm asking you what the implications are. So it does state that.
It seems to me I'm a little uncomfortable because I feel like you're asking me legal interpretation, which we've spent a lot of time talking about whether I'm qualified to comment on.
Was that an I don't know?
Why don't you rephrase your question for me?
Okay. Well, how about we just confirm the language that the implications of the case American Water Works and Association of Metropolitan Water Agencies has the potential to force water regulations to be reduced. Is that correct?
Objection, Foundation.
Sustain.
So we're looking at page 7, line 22. The question asks, have there been any legal challenges to the PFAS drinking water regulations? And I'm asking you to confirm that in Ms. Azad's testimony, not whether you agree or not, but that in her testimony, she states that that lawsuit could, and again, this is from page 7, line 22, and page 8 up to line 5, which answers the two questions. Have there been any legal challenges to the PFAS drinking water regulations? And how might the result of these legal challenges impact water systems? That if those challenges are successful, then the EPA may have to take steps to modify their regulations. Is that what this statement before you says?
It's my understanding.
Mr. Cosgrove, can you explain what part of these statements from Mrs. Odd's testimony, which describe the EPA's PFAS drinking water regulations, may be reduced, or as you put it in your testimony, become more relaxed, are unclear to you?
I'm sorry, I don't understand your question.
So in your testimony, you had stated that I'm looking at page 12 of your testimony, line 14 and 15, where it states it is unclear what the basis of this belief is, and that's the belief that PFAS MCLs may become more relaxed. And we just read together portions of Mrs. Odd's testimony where she indicates that the reason those PFAS drinking regulations may become more lax is the result of pending litigation that was filed in 2024. So the question is, what about that is unclear such that you're unable to determine what the basis of her statement is?
I think we're talking about two different issues. On page 12 of my testimony, I'm talking about the fact that EPA has discussed possible changes to the regulations with respect to the PFAS MCLs. But those changes were not proposed, or no changes were proposed for the PFOA or the PFOS MCLs. And so what I'm saying, starting on line 14 of page 12 of my testimony, is that, I own up to the fact that MCLs for PFNA, PFN, like Nancy, A, PFHXS, and Gen X and mixtures have been informally proposed for reconsideration. No formal action has been taken. So that's what I'm alluding to in that paragraph.
But in Ms. Azad's testimony that we just read together, she specifically says that it's the result of this American Water Works Association litigation that informs the possibility that PFAS MCLs might become more relaxed.
I don't know the details of that litigation, so I can't comment on that litigation.
But in reviewing her testimony, you read her testimony and you made the statement here that the basis of her opinion, belief that PFAS MCLs may become more relaxed is unclear to you.
Yes, I did.
I'm sorry, Your Honor. I'm trying to figure out if the portion I'm trying to ask a question about has been stricken.
Fine.
All right, I'm back. On page 26 of your rebuttal testimony, lines 5 through 6, you state witness Azad, and we're referring here to Ara Azad, is suggesting that the media changeout should not be used until penalties for violating the MCLs are effective in 2029. Is that correct?
Yes.
Your Honor, may I approach the witness? I handed you a copy of Ms. Ara Azad's revenue requirement testimony. And like we had discussed before, I took a break to find the right testimony. You stated on page 26, lines 5 through 6 of your testimony that witness Ara Azad suggests that the media changeout should not be used until penalties for violating the MCLs are effective in 2029. Can you tell me where in Ms. Ara Azad's testimony she provided an opinion as to when Veolia should use or should not use media changeouts in its PFAS plant?
Well, the document you handed me is 118 pages. You'll have to give me a minute to find it.
Can you direct the witness to a section to move this along?
I believe the point is that there is not a section.
We don't have enough time for him to go through the entire document. Was there a section of the document where the witness addressed this issue? And your position is that he did not address the issue, but is there a section of the document where he addressed the issue?
It is on page 19, starting at section 3 that discusses chemicals. And that's where PFAS media changeout is discussed.
Yes, I see that. But later in the document, there is a section that describes, I believe it was a bullet list, and it describes what Veolia would need to do in order to convince her that these were viable expenses. I don't remember the details, but I do remember the list pretty well.
You expand on the list so I can try and find it.
Look for a bullet list with, I'm going to guess 3 or 4 bullets or maybe more in it.
I believe we're looking for page 80. And that starts page 7, where it talks about what is the rate base accounted for in your recommended revenue requirement. So In that section, I think that's the section you were referencing. Can you tell me where Mrs. Zod has provided an opinion as to when Veolia should use or not use media changeouts as it relates to O&M expenses?
Would you mind referring back to my testimony on the statement that you're asking me to comment on?
Yes, so we are looking at your testimony at page 26. That first question, it starts at line 1, where it's specifically where you say witness Azad is suggesting that the media should not be used until penalties for violating the MCLs are effective in 2029.
And number 2 of her list here says federal and/or Delaware state PFAS regulations become enforceable.
Did you provide testimony on rate base?
No,
And did you you provided testimony on other O&M expenses, correct?
yes,
Okay. In this section that we're referencing on page 80 of Mrs. Odd's testimony refers specifically to rate base. Is that correct?
question refers to rate base, yes.
Thank you. Going back to your testimony on page 26, lines 19 and 20, you state that these costs are referring to the costs of those PFAS O&M expenses, particularly relating to the media changeouts, are known and measurable. Is that correct?
That's correct.
Now, in the context of a rate proceeding and in accordance with regulatory accounting principles, what does the term known and measurable mean?
I think we have a difference in definition here. I'm talking about known and measurable as an engineer. I'm not talking about the definition that you may be using with respect to rate base.
What is known and measurable in your understanding?
In my understanding, it's the fact that the cost of the media is known. We have a contract with a vendor that provides to us an exact cost per weight of material. And we know what the weight of material is in each vessel. We know how many vessels we have. So therefore, we can very easily calculate the total cost. That cost is known and measurable.
And are you familiar with witness Fetcher's testimony for the company?
I am.
So before you, you should have a copy of Ms. Fetcher's rebuttal testimony.
I do.
Fetcher's rebuttal testimony is admitted as Exhibit 5. Can you please turn to page 52 of Ms. Fetcher's testimony?
I'm there.
At lines 16 and 17, Ms. Fetcher states, the pilot results and full-scale sampling to date indicate that the change-out frequency, and that's the change-out frequency of PFAS media, is still unknown. Is that correct?
Yes.
Do you agree or disagree with Ms. Fetcher's statement that the change-out frequency of the PFAS media was unknown at the time of the rebuttal testimony?
I agree.
Since it is unknown how often the company will need to change the PFAS media, the company cannot know how how much it will spend in a year on PFAS media, correct?
The company will estimate how much it will spend in a year for PFAS media, just like they do many things in the plant, other chemicals, for example.
So if the company doesn't know how much and they're just estimating, then the cost can't be known and measurable, correct?
The cost of the media is known and measurable.
But only the media, not to how often you're going to need to change it in a year.
You would make an estimate to do that.
Going back to your rebuttal testimony, I'm looking at page 21.
Okay.
Starting on line 13, that section of your testimony explains why you believe that the company considered alternatives prior to constructing the PFAS plant. Is that correct?
Yes.
Can you describe your involvement in the company's planning, analysis, and decision-making process to build the PFAS treatment center at the Stanton Water Treatment Plant?
I was not involved.
On page 21, lines 15 and 16, you state that in reviewing the rebuttal testimony of company witnesses Fetcher and Murray, it is my opinion that the company engaged in a rigorous alternative analysis. Is that correct?
Yes.
So you based your opinion that the company adequately considered alternatives prior to constructing its PFAS plant on the testimony of other witnesses. Is that correct?
Yes. And other documents that I was provided.
And what other documents did you review when assessing the company's consideration of these alternatives?
There is a list in my one of my response to questions, but I can't list everything off the top of my head here.
So there are documents that you reviewed, though.
Yes.
On page 9 of your rebuttal testimony, you reference Delaware's Senate Bill 72. And then you state, starting on line 6, that Delaware adopted the EPA's existing PFAS MCLs into Delaware regulations. Is that correct?
Yes.
Mr. Cosgrove, in your opinion, would it be sound judgment to make business decisions based on an accountant's input over the input of an engineer when concluding on matters requiring engineering expertise?
Can you say that one more time?
So, on a matter that requires an engineer's expertise, would it be sound judgment to make a decision based on an accountant's input over that of an engineer?
If it was related to an engineering matter, I think the decision would be better placed with an engineer.
On that same vein, when concluding on matters requiring an engineer's expertise, in your opinion, would it be sound judgment to make a decision based on a lawyer's input over that of an engineer?
I think the legal aspects could be important, so I'm having difficulty answering your question.
What if it was an engineering requirement? You had to pick one, engineer or lawyer. Who would you listen to?
Say that one more time.
If you had a decision to make and it was on an engineering matter and you got advice from a lawyer and you got advice from a engineer, whose advice would you listen to? Whose advice would you give greater weight to?
Objection. There's no foundation. He can't answer. There's no facts. It calls for speculation.
It's a hypothetical.
Sustain.
Your Honor, it's a hypothetical question asking
A
about.
hypothetical that's not based on any facts in this case.
It is based on facts in this case, as he is an engineer giving opinions about or explaining regulations, laying out regulations, talking about understanding of regulations. Even though we've stricken a lot of them from the record, they're still there.
The way that your question was phrased did not include any facts. It simply presented him, would you agree with an accountant or a lawyer on an engineering matter? And that's my objection, Your Honor.
I sustain the objection. It's too open-ended.
Thank you. No further questions.
DPA,
None from the DPA, Your Honor.
redirect company.
Thank you, Your Honor. Good morning, Mr. Cosgrove. Do you recall speaking with Ms. Workman about the potential for the relaxation of PFAS and other associated regulations?
I do.
To your knowledge, has the EPA ever indicated an intent or published notice of its intent to relax its MCL regulation limiting PFOA or PFOS in drinking water?
They have not.
Earlier, I believe you conceded that you are not an attorney, correct? As part of your responsibilities with your firm is One Water Consulting, correct?
Yes.
Do you have the opportunity? Sorry, it's your firm is One Water Accounting, correct? Consulting. I'm sorry. I'm trying to build you up here. As part of your responsibilities there, can you tell me how you interact with regulations and statutes?
Right. My business is built on evaluating regulations and advising my clients on those regulations. So literally every day of my career, I am evaluating the impact of regulations on my clients and making recommendations, sometimes with attorneys, on what action they need to take, if any, and if so, what that action may be.
And when you are making those decisions, do you often find that you're only consulting just a lawyer or just an accountant or just an engineer?
No, in fact, that's what we take great pride in, is that we work with all of them to make decisions together.
Do you recall speaking with Ms. Workman concerning the American Water Works Association litigation?
Yes.
Are you aware of any changes to PFAS regulations as a result of that litigation?
I don't believe there have been any changes.
I object to that. He said he was unfamiliar with that litigation.
Overruled.
Can I ask you, Mr. Cosgrove, to, excuse me, go back to page 26 of your rebuttal testimony, please? And do you recall speaking with Ms. Workman? She had asked you specifically regarding lines 4 through 6 on page 26 about witness Ara Azad suggesting that media should not be used until penalties for violating the MCLs are effective in 2029. Do you recall that discussion? And you still have Ms. Azad's testimony before you, correct? Ara Azad's testimony.
I do.
Can you please turn to page 21 of that testimony for me, please?
I am there.
Thank you. Can you read from page 21, line 22 through page 22 to line 9, please?
Can you say those lines again?
From page 21, line 22 to page 22, line 8.
Okay, I've read it.
With respect to the testimony that you just read, does that refresh your recollection as to Mrs. Odd's suggestion that media should not be used until penalties for violating the MCLs are effective in 2029?
So I appreciate you pointing that out because I could not find it.
Is that the testimony that you were responding to?
Yes, it is.
We talked a little bit, going back to our conversation about the EPA potentially relaxing drinking water regulations. How long have you been in this business, Mr. Cosgrove?
39 years.
In your experience and to your knowledge, has the EPA ever relaxed a drinking water contaminant MCL?
Not that I can recall. Normally they get more stringent.
Do you recall speaking with Ms. Workman concerning the known and measurable component of the media change-out costs?
Yes,
And I believe you said that your testimony was from an engineering perspective, correct?
that's correct.
Do you have Ms. Fetcher's testimony in front of you?
I do.
Could you refer to page 66, please? And take a moment to review the table on that page and the testimony when you get there.
You're asking about table 8.
Table 8 on page 66, correct.
Got it.
I believe your testimony was that the costs of the PFAS media changeouts are effectively locked in. Is that correct?
Yes.
Are you able to tell me what table 8 suggests about the frequency of the changeouts?
It suggests that the frequency is 183 days.
Is that known and measurable from an engineering perspective?
Yes.
I have no further questions for Mr. Cosgrove.
Staff.
Your testimony, you had referenced Miss Ara Azad's testimony, and you stated that she was suggesting that the media should not be used until penalties for violating the MCLs are effective in 2029. Going back to page 21 and 22 of Mrs. Odd's testimony, in that section, is there anywhere where she references 2029?
In item number 1 on the bottom, on the top of page 22, she states the compliance deadlines for the regulations Veolia cites are the reasons for incurring the PFAS-related costs are years in the future. And I believe she's referring to the fact that the regulations, the MCLs that we've been discussing, are set to, I'm trying to think of the word I should use, because they are effective today in the regulations, but they penalties for not achieving those MCLs would occur in 2029.
And is Miss Azad here giving an opinion on when those costs are recoverable or when the company should use the PFAS media?
Objection, which Mrs. Odd?
I'm sorry, Miss Ara Azad, whose testimony we're looking at.
Well, on the bottom of page 21, she talks about how the PFAS-related expenditures have been preemptively incurred. So it was my understanding that she was suggesting that those costs should not be incurred now. The only way those costs could not be incurred now is if that treatment plant was not being utilized.
But just to be clear, her testimony is about recovery of costs, correct?
Her testimony is about recovery of costs, but those costs are going to occur while the treatment plant is in operation.
Mr. Cosgrove, you mentioned that you often consult with attorneys when in the course of your work. Is that correct?
Yes.
And did you discuss the potential for PFAS MCLs to be rescinded with an attorney in providing your opinion?
Objection calls for privileged conversations.
Overruled.
I did discuss this with attorneys. I'm currently involved in PFAS matters in New Jersey, and I'm actively working with attorneys on that matter. And I did ask them their opinion on this matter.
So you are aware of the legal arguments that are being made, not what they are, how they're going to do, but just that there are legal arguments being made to rescind PFAS MCLs?
Objection to the phrase legal arguments.
Just that these arguments exist, not that he has an understanding or an interpretation of them.
Same objection. The phrase legal arguments is too vague and broad.
Sustain.
What? Oh, the EPA. Legal argument. So there are legal arguments by the EPA. The EPA is making to rescind PFAS MCLs. Are you familiar with those?
Same objection.
We narrowed it down to just legal arguments made by the EPA.
Also lack of foundation.
Overruled. Can you please testify as to just what you know?
Sure. I am aware of litigation that's been filed on PFAS MCLs. And I am aware that EPA has suggested that they may remove MCLs for certain of the PFAS chemicals. And I'm also aware of the fact that they have specifically stated they will not be removing MCLs for PFOA and PFOS.
So, just to be clear, you are not speaking to the legal mechanics which are available or in the process for rescinding MCLs. That's correct?
Objection to the phrase legal mechanics. I'm not sure what that refers to.
Sustain.
No further questions.
EPA.
No questions.
Okay, let's go off
Your
the
Honor,
record
I'm sorry. I have one very quick question on the scope of her.
quickly.
Thank you, Your Honor. Mr. Cosgrove, when Ms. Workman was asking you what informed your decision about Mrs. Azad, where was 2029 and Ms. Ara Azad's testimony? Do you recall that? Can you refer to page 6 of Ms. Azad's testimony, Ms. Ara Azad's testimony? Page 6, line 1. What does it state?
Line 1.
Yes, page 6, line 1. Can you read what it says there?
Starting with the word recommendation?
Yes.
Okay. Recommendations of my cost of capital testimony and by my testimony of staff witness Ava Azad addressing the regulatory context at the federal and state levels as they pertain to PFAS-related compliance for consideration in the current proceeding.
So is it your understanding, based on that statement, that Ms. Ara Azad relied on the testimony of Ms. Ava Azad in formulating her recommendations with respect to PFAS O&M?
Yes.
And do you have Ms. Ava Azad's testimony in front of you?
Yes, I do.
Can you please turn to page 6, lines 15 to 16? What date do you see there, Mr. Cosgrove?
I see the date, April 26, 2029.
And what does Ms. Azad say about that date?
She said that the systems may be assessed MCL violations beginning on that day.
Thank you.
Staff,
Nothing from staff.
DPA. Okay, let's go off the record for a 15-minute bathroom break. Company, will you please call your next witness?
Yes, Your Honor. The company calls Ian McDougall.
I do.
May I approach, Your Honor?
Yes.
Good morning, Mr. McDougall. How are you?
Doing well. How are you?
Good. I just handed you two documents. Can you please tell me what they are?
Yes, they are my direct and rebuttal testimonies.
And did you prepare both of those documents?
Yes, I did.
With respect to your direct testimony, do you have any corrections in that document?
Yes, I have one correction. On page 1, starting on line 3, my business address has changed. My business address is now 520 Lane Cook Road, Suite 275, Deerfield, Illinois, 60015.
Any other corrections with respect to your direct testimony?
No,
Do you have any corrections with respect to your rebuttal testimony?
not.
Concerning your direct testimony, if I were to ask you all of the questions contained in that testimony again this morning, would your answers be the same?
Yes, they would.
With respect to your rebuttal testimony, if I were to ask you all of the questions contained in your rebuttal testimony again this morning, would your answers be the same?
Yes, they would.
Thank you. At this point, Your Honor, I would ask for Mr. McDougall's direct testimony to be moved into evidence as Exhibit 16 and his rebuttal testimony as Exhibit 17.
Any objections, staff?
No objections.
DPA?
No objections.
McDougall testimony direct is admitted into evidence as Exhibit 16. McDougall testimony rebuttal is admitted into evidence as Exhibit 17.
Thank you, Your Honor. At this point, I don't have any other further questions for Mr. McDougall on direct.
Staff Cross?
I apologize. No cross.
EPA?
Yes, Your Honor. Mr. McDougall, where is Deerfield in Illinois?
It's just outside of Chicago.
Okay. And is this your first time testifying before the Delaware Public Service Commission?
It is.
Okay, well, welcome, sir. Now, I want to just focus on your rebuttal testimony mostly. Mr. McDougall, am I correct that you disagree with Mr. Watkins' treatment and the calculation of cash working capital?
Yes, I do.
Okay. And trying to focus on the issues here. Am I correct that the only difference between yours or the company's cash working capital model and that performed by Mr. Watkins is that you've included depreciation expense within your cash working capital allowance while Mr. Watkins excluded depreciation expense, correct?
That is correct.
Okay. And you have a copy of your rebuttal testimony in front of you, sir?
Yes, I do.
Okay. If you can go to page 2, lines 3 through 5.
Yes, I'm there.
Okay. So there you say you indicate there is precedent for including certain non-cash expenses such as depreciation in the calculation of CWC, correct?
That is correct.
Okay. And then in your rebuttal testimony, you give some examples, sir.
Yes, I do.
Okay. And on the bottom of page 3 and on to page 3, your rebuttal testimony, you refer to EPCOR Water Services. What is EPCOR Water Services?
It's a water company.
And my understanding that's in the city of Edmonton, correct?
This specific case is yes.
Okay. Edmonton in Canada?
Yes.
All right. And then going on to the middle of page 3, you talk about in your rebuttal testimony, you refer to the New Jersey American Water Company. And I take it that company is located in New Jersey?
It is.
Okay. And then also on page 3, you talk about the Jersey Central Power and Light Company. Is that also in New Jersey, sir?
Yes, it is.
Okay. And then going on to page 4, which is the last page of your testimony, you talk about Atmos Energy, and that's in Tennessee, correct?
It is in multiple states, but Tennessee is the case I'm referring to, yes.
Okay. Okay. And where in Tennessee was that, sir?
I'm not certain specifically.
Okay. And then also on page 4, you talk about Edison, which was in Southern California, correct?
Yes, sir.
Okay. And sir, have you conducted any research in how the Delaware Public Service Commission has treated the inclusion or exclusion of depreciation expenses within cash working capital in the past?
The only thing I have really looked at was the case brought up by Mr. Watkins in his testimony.
Okay. All right. Thank you, sir. With permission to approach the witness. All right, sir. I've made the rounds around here. Um, um, have you had a chance to take a look at any of the documents there?
Yes, I have.
Okay. So I want to start with the document number 24-2044, which is I'll represent as a cash working capital study conducted by Delmarva Power and Light in a recent natural gas case.
I have a 24-1044. I don't have a 2044.
It's 24-1044.
Yes, I have that.
My apologies. And have you had a chance to take a look at it? Take your time, sir.
Yes, I have.
Okay. Your Honor, I'd like to, in terms of for identification purposes, this I guess would be DPA exhibits.
Would you like to mark it as Exhibit 18, just for identification purposes?
For now, Your Honor.
Okay. I'm going to mark docket number 24-1044, Delmarva Power and Light Company, gas base rate case, minimum filing requirements. And that's marked for identification purposes only.
And Mr. McDougall, looking at this document here, can you tell me if you see if Delmarva Power and Light, or DPL as it's collectively known here, included or excluded depreciation within its cash working capital requirement?
I do not see depreciation expense included in their cash working capital.
All right. And then moving on to the next document, which I would ask be marked for identification purposes as exhibit, I guess, 19, and that's docket number 22-0897. Oh, sorry. Not used to using microphones as much. Have you had a chance to look at that, sir?
Give me one moment.
Sure, take your time.
Davey, you said that it's 220897.
22-0897. It's titled Electric Base Rate Case Minimum Filing Requirements.
I don't believe you gave me a copy of that.
I think you gave me 2 copies of it.
Well, there you go.
Okay, that's going to be, I'm marking as Exhibit 19, docket number 22-0897, electric base rate case, minimum filing requirements. That's marked for identification purposes.
Okay, sir. And have you had a chance to look at this document?
Yes, I have.
Okay. And after reviewing this document, which contains DPL's cash working capital calculations, can you tell me whether or not if you see that DPL included or excluded depreciation within its cash working capital requirement?
I do not see depreciation expense included in this cash working capital.
Yeah. And that's an electric case, correct?
Yes.
Okay. All right. And going on to the next document, which is listed as Chesapeake Utilities Corporation, docket number 24-0906, gas base rate case minimum filing requirements. Let me know when you've had a moment to look at that document, sir.
I have.
Okay. And basically same questions as previously. After looking at this document, Your Honor, I'd ask that this be marked for identification purposes as
Number Exhibit 20, I'm marking as Exhibit 20 for identification purposes. PSC docket number 25-0346, application of Artesian Water Company, Inc. for a revision of rates is the title. It's a two-sided
I'm actually
document.
talking about Chesapeake right now, Your Honor, and then I will actually get to.
Oh, okay.
My apologies for any confusion.
Okay.
Um,
Let me, okay, so strike that, and I will mark as 20 Chesapeake Utilities Corporation, docket number 24-0906, gas base rate case, minimum filing requirements. That will be 20, and it's marked for identification purposes.
All right, so Mr. McDougall, so we're focused on the Chesapeake document right now. Basic same questions as previous. As you're looking at this document regarding Chesapeake's cash working capital calculations, can you tell me whether Chesapeake included or excluded depreciation within its cash working capital requirements?
I do not see depreciation expense in this document.
Okay. And the last document, which I think we're now at 21, Your Honor?
21.
I do not have any other documents that you provided me.
Okay, while you're looking for that, I'm marking as Exhibit 21 for identification purposes now, application of Artesian Water Company, Inc. for a revision of rates.
Barry, take your time. The front and back. There's a front and back to the document.
I've reviewed it.
All right. So, and with this document, Mr. McDougall, this is Artesian Water Company and its pending water case, docket number 25-00346. Basic same questions as previously. As you review this document regarding Artesian's cash working capital calculations, can you tell me if Artesian included or excluded depreciation within its cash working capital requirement?
I do not see any depreciation expense in this document.
Okay. Um, so these are some recent Delaware cases before the Delaware Public Service Commission service, and you testified this is your first time testifying before the Delaware Public Service Commission, correct?
Yes, sir.
Okay. And the examples that you gave were from a couple of jurisdictions out of state and also in Canada, correct?
Yes.
Okay. But in your direct testimony, you didn't give any Delaware examples, correct?
Well, no, but I'm also aware that commissions don't operate in a vacuum, that commissions will also, will always look at other commissions throughout the country and in other countries in what they might choose to do.
Respectfully, sir, that wasn't my question. Are you aware of any specific Delaware examples?
No.
Thank you. No further questions.
Redirect. Let me ask a question of the DPA. Exhibits 18, 19, 20, and 21 were marked for identification purposes. Are you attempting to move them into evidence?
I would like to move them into evidence now, Your Honor.
Okay. Is there any objection from staff as to moving exhibits 18, 19, 20, and 21 into evidence?
No objection.
Any objection from the company?
I would just ask for a proffer, Your Honor. I believe that Mr. Crumpler said that the Artesian case was pending, but could you provide a proffer on the status of the other three?
They've been recently filed and litigated cases in Delaware, and Mr. Watkins can talk about these during his testimony as well, if necessary.
Were the three other cases litigated or settled?
One is, yeah, I think one is currently in litigation. The other two have been settled. One second. So the two gas cases are being litigated currently. Sorry, my apologies. Two gas cases settled. The electric case is pending, and the Artesian water case is actually scheduled.
No, the electric case, that was litigated because there was recently a new electric case filed. Should we should we have Mr. Watkins describe?
I have no objection to that, Your Honor.
Mr. Watkins, would you describe what you know about this?
And use of microphone.
Yes, Your Honor. As you know, I regularly testify before the commission. In fact, every rate case comes before the commission. These documents are the result of the cost of the cash working capital models for these four different utilities that I've been involved in.
Objection, Your Honor. I just want to know if the cases are settled or pending, or that's the purpose of the proffer. So
My apologies, Counselor. Yes, the electric case was litigated. The two gas cases were settled, and the Artesian case is pending.
thank you. With that clarification, no objection.
Okay. So exhibit 18, 19, 20, and 21, those four exhibits are admitted into evidence. Now, do you have redirect?
No, Your Honor.
Okay. Thank you, sir. Okay, so please call your next witness.
The company calls Mr. Harold Walker.
I do.
Good morning, Mr. Walker. How are you?
Good. How are you?
Good, thank you. Your Honor, may I approach?
Yes.
Mr. Walker, do you have copies, or excuse me, did you prepare testimony in this case?
Did.
And can you tell me which testimonies you prepared?
I prepared a direct testimony and a rebuttal testimony concerning cost of capital.
And do you have copies of those testimonies before
I
you?
do.
With respect to your direct testimony, if I were to ask you all of the questions contained in that direct testimony again this morning, would your answers be the same?
Yes.
With respect to your rebuttal testimony, if I were to ask you all of the questions contained in that document again this morning, would your answers change?
No, with the exception of one correction in my rebuttal testimony.
What is that correction?
On page 22, line 19, the number 10.19% should be 10.8%. I'm sorry, the number 10.9% should be 10.8%.
Thank you. Other than that, any corrections?
No.
At this point, Your Honor, I would request Mr. Walker, with respect to that line, you identified that number 10.9%. It appears twice. It seems to appear twice on that line. I just want to make sure which instance you're referring to.
The second 10.9%. When compared to my original recommendation of my testimony stated 10.9%, that should be 10.8%.
Thank you. Your Honor, at this point, I would offer Mr. Walker's direct testimony as Exhibit 22 and his rebuttal as Exhibit 23.
Any objection, staff?
Objection from staff.
DPA?
No objections from the DPA.
Okay. Those exhibits are admitted into evidence.
And I have no further questions for Mr. Walker on direct.
Staff Cross?
Your Honor, may I pass out a document?
Yes. Thank you.
Thank you.
Your Honor, before we get started, I'm going to be going over information that was designated by the company as confidential in this cross-examination. So could I ask these questions in a non-public setting?
If there's anyone in the room that does not have a confidential status in this case, please leave the room. And please make a note. Please stop Zoom and
Are we prepared to proceed, Your Honor?
yes.
Okay. I know Your Honor said that we were planning to break at 12:30. I don't know.
That's a hard break because you all want hot pizza.
I think the answer from everyone is yes. So with 20 minutes, Your Honor, I defer to you, but I don't know if that's going to be a wise choice to begin our next witness with that hard break at 12:30.
Your Honor, if I could say one matter, Mr. Watkins is here. He has to leave at 3 o'clock. Again, he'd be called out of order, but and I know Your Honor has graciously allowed him to testify virtually, but if necessary, we can put him on this afternoon. I know the companies had some scheduling conflicts, which is why they wanted the hearing to continue early next week. And that's Mr. Watkins, had to go back to Virginia. So anyway, I just wanted to throw that out there again, and I think his testimony is going to be brief. But I also understand that the company has the prerogative in terms of their order of witnesses.
Well, we only have 20 minutes.
Your Honor, the company is not prepared to take Mr. Watkins at this time.
Right.
With apologies to Mr. Watkins.
But you're not prepared for Mr. Watkins?
I don't think anyone's prepared for Mr. Watkins.
That's on the record.
Okay, let's off the record now. Let's just break for lunch and let me go see what's happening with lunch, and we'll start up. I'll make some sort of announcement.
Yeah, and Mr. Walker is excused, correct?
Yes. Will the company call its next witness, please?
Yes, Your Honor. The company calls Anupa Jacob. May I approach, Your Honor?
Yes.
Good afternoon, Ms. Jacob.
Afternoon.
I just handed you 2 documents. Can you tell me what they are, please?
Yes, one is my direct testimony and one is my rebuttal testimony.
And did you prepare both of those testimonies in this case?
Yes, I did.
With respect to either of those testimonies, do you have any corrections?
No, I do not.
If I were to ask you the same questions in both your direct and rebuttal testimonies today, would your answers to any of those questions change?
Wouldn't.
At this point, Your Honor, I'd like to move for the admission of Ms. Jacobs' direct testimony as exhibit number 25 and her rebuttal testimony as exhibit number 26.
Any objections, staff?
No objection.
EPA?
No objections, Your Honor.
Okay, Ms. Jacobs' direct is admitted into evidence as exhibit 25, and Ms. Jacobs' rebuttal testimony is admitted into evidence as exhibit 26.
Thank you, Your Honor. I don't have any other questions for Ms. Jacob on direct.
Staff Cross?
Your Honor, may I approach and pass out documents?
Yes.
Thank you for your patience. Are you ready to begin?
Yes.
On page 4, line 15 of your rebuttal testimony, you reference a black box agreement, and you state that staff did not address the company's TCJA adjustments because all TCJA matters would be handled as part of its review in PSC docket number 17-1240, correct?
That's correct.
In front of you, you have order number 9599. And take your time looking through the order when I ask you this question. Was a TCJA reduction of base rates accounted for in order number 9599?
Or a specific
Well,
page you can,
what about the settlement agreement, page 6, paragraph 21? Does that speed things along here?
As the hearing examiner said, page 621, but I wanted her to also have an opportunity to make sure it's not addressed elsewhere as well.
Well, sure. I mean, she can go through page by page. There's, unlike the other witness, I mean, this is manageable.
Can you please, now that I've briefly looked at it, repeat your question?
Yes. So was a TCJA reduction of base rates accounted for in order number 9599, which is the order we're looking at right now?
A specific reduction?
Yes.
Is that what you're asking me?
Yes.
In the order itself, there is not a specific reduction allowed.
Thank you. In your rebuttal testimony on page 4, starting at line 21, you please read, and you can read this to yourself, page 4, line 21 through page 5, line 6. And let me know when you're done.
I'm done reading.
Going back to that page we were on from order number 9599, which was Exhibit A, which is the settlement agreement, page 6. Would you agree that, I'm sorry, page 6 of the settlement agreement, paragraph 21, it's at the top.
Yeah, I read that.
Would you agree that that says that the TCJA is going to be continued to be addressed in docket number 17-1240?
Yes.
And then take a look at order number 10030. 10030. I want to direct your attention to page 4, paragraph number 2. It's at the very bottom.
Yes, I see it.
Would you agree that in this order, the commission ordered that the issue of the amortization period, which of non-protected assets, was going to be considered in the next rate base case for Suez Water Delaware?
Yes.
And the next base rate case was the rate case that was filed in 2023. That's docket number 23-0598. Is that correct?
That's correct.
Your testimony at page 5, line 10. Oh, I'm sorry. Rebuttal. If I forget to say rebuttal, it's rebuttal. Thank you. So that's your rebuttal testimony, page 5, line 10. You state the settlement agreement in 23-0598 was a black box agreement. Is that correct?
That's correct.
Can you explain what a black box agreement is?
I will speak as, from perspective of an accountant and not a rate specialist. My understanding of a black box agreement is that the specific terms are not necessarily outlined, not all of them. And it's a result of settlement discussions.
Thank you. So in your rebuttal testimony on page 5, line 23, you go on to say that both staff and the DPA accepted the proposed changes to the protected and unprotected amortizations in their direct testimonies. Is that correct?
That's correct.
Before you, you should have order number 10409.
I have it.
In that order which is the settlement order for the last base rate case. Is there a specific mention of the TCJA in that settlement agreement that starts at Exhibit A?
No, there isn't.
And in that same document, Exhibit A, page 8, paragraph 5.
I'm sorry, did you say page 8, paragraph 5?
I apologize. Page 8, definitely not page 8. Give me a minute. We'll come back to that if I find it. Page 8, paragraph 28. That first line, that says, this settlement agreement resolves all of the issues specifically addressed herein. Is that correct?
Yes.
And then on page 6, paragraph 20 of the same document, This states, no party to this settlement agreement necessarily agrees or disagrees with the treatment of any particular item, any procedure followed, any calculation made, or the resolution of any particular issue, except that the parties agree that the resolution of the issues herein, taken as a whole, results in a just and reasonable rates and is in the public interest. Is that correct?
Yes.
And then looking at Exhibit A, paragraph 6, or I'm sorry, page 6, paragraph 21, which is right below it. It says, to the extent opinion or views were expressed or issues were raised in the pre-filed testimony that are not specifically addressed in this settlement agreement, no findings, recommendations, or positions with respect to such opinions, views, or issues should be implied or inferred. Is that correct?
Yes.
In your understanding, what does it mean when the order says no such issues should be implied or inferred?
I think it means that what it says, or we're not to imply in any particular take or any inference besides what's in the agreement.
Referring back to your rebuttal testimony, can you please take a look at beginning at page 6, line 2, and then read to yourself to page 9, line 11. Let me know when you're ready.
Can you make the page reference again?
Yes, starting on page 6, line 2, and then down to page 9, line 11.
I'm done.
Thank you. So in that testimony that you just read, you indicate that the company based their decisions regarding their treatment of TCJA on pre-filed testimony in that case. Is that correct?
In which case?
Apologize. The base rate case 23-0598.
Yes.
In front of you, you also have order number 10460. Do you see that?
Yes.
All right. In the top of the first page, the case caption is the matter of the application of Artesian Water Company for an increase in water base rates. Is that correct?
That's correct.
So this is your understanding. Well, I guess you also see at the top there, order number 10460. Is that correct?
That's correct.
And if you'll turn to Exhibit A on the first page of Exhibit A. This is a settlement agreement, correct?
That's correct.
So is it your understanding that the document in front of you, order number 10460, is a settlement agreement in the matter of the application of Artesian Water Company for an increase in water base rates?
That's what it says.
Thank you. Your Honor, I'd like to mark order number 10460 as an exhibit.
It would be Exhibit 27. DPA, any objection?
No objections, Your Honor.
Company, any objection?
Objection, Your Honor.
Okay. Order number 1460 from the case in the matter of the application of Artesian Water Company, Inc. for an increase in water base rates. ESC docket number 23-0601 is marked as exhibit number 27 and is admitted into evidence.
Can you please turn on Exhibit A to page 5, paragraph 22? And then go ahead and read that to yourself and let me know when you're ready.
I did.
And in that paragraph, the settlement agreement from the Artesian base rate case, docket number 23-0601, explicitly lays out how Artesian is going to handle these TCJA amortizations in the settlement agreement. Is that correct?
Not all of it, just the non-protected portion.
Thank you. In front of you, you also have order number 10768.
I have it.
And there at the top, it says in the matter of the application of Tidewater Utilities for a general increase in rates. You see that?
I do.
And that is order number 10768. You see that?
I do.
And then turning to Exhibit A, about 10 pages in.
I'm there.
See at the top where it says settlement agreement?
I do.
Is it your understanding that this order is a settlement agreement ordered, well, an order which issues a settlement agreement for this Tidewater rate case?
Yep, that's what it says.
Can you please turn to Exhibit A, page Exhibit A, paragraph 16. There are not page numbers. I apologize. It's in section 2, settlement provisions, and then starting at the top of the page, paragraph 16. Do you see that?
I do.
Can you read that to yourself? The paragraph 16 and all of the subparts to that?
I did.
And is it your understanding that that paragraph lays out how Tidewater must address the TCJA?
I think there's definitely additional facts in here that I wouldn't be aware of, but I think in general, it outlays certain instructions around it.
Okay, thank you. I have no further question. Oh, before we stop, I would like to move order number 10768 into evidence.
It would be Exhibit 28. DPA, any objection?
No objections, Your Honor.
Company?
No objection.
Okay, I am admitting into evidence order number 1768 from in the matter of the application of Tidewater Utilities, Inc. for a general increase in rates, docket number 24-0991. It's exhibit number 28.
Can we just take a short break? I need to fish out a document from one of the boxes over here.
Okay.
Thank you. And may I approach?
Right, we're on redirect.
Ms. Jacob, take a moment to review that document when you've had the opportunity. Just look up and let me know.
I'm done.
Thank you. You were speaking with Ms. Workman concerning the company's treatment of TCJA liability, and you had the opportunity to review this response PSC 5.27, correct?
That's correct?
And are you generally familiar with the contents of this document?
Yes.
And do you recall Ms. Workman's question to you concerning whether the TCJA liability was reflected in a reduction in base rates?
Yes.
And after reviewing this document, can you provide further explanation on that?
Yes, the through the order 9319, it does specifically, the order does specifically allow the reduction in base rates.
Thank you. And with respect to your rebuttal testimony, page 4, line 15,
I'm there?
you refer to order 9599 there, correct?
Yes.
And you discussed that order with Ms. Workman, right?
Yes.
Was TCJA amortization specifically disallowed in that order?
It was not specifically disallowed.
Shortly after you discuss order 9599 in your rebuttal testimony, you also discuss order 10030 in docket 210245. Do you see that?
I do?
Do you recall if TCJA amortization was disallowed in that docket specifically?
It was not disallowed specifically.
At any point on any docket or order for the company since the income tax reduction on January 1st, 2018, has there been an explicit request for the company to use a tracker for TCJA purposes?
Nope.
And has the company changed its method with respect or its approach with respect to TCJA?
No, it has not.
To your knowledge, has any party in this proceeding requested that the company prior to this proceeding change its approach to TCJA?
Are you referring to the accounting of TCJA?
Yes.
No.
I have no further questions.
Staff?
Referring to PSC 5.27 that you just reviewed with Mr. Simon. Looking at Part B of the question or of the request. It says, if all base rate proceedings in which Veolia has participated in Delaware since December 31st, 2017 have resulted in an increase to base rates, confirm. Is that a correct statement? Not that it's correct in the document, but is it true that all base rate proceedings in which Veolia has participated since December 31st, 2017 have resulted in an increase to base rates?
Is your question just a specific base rate, general base rates?
Yes.
Yeah, base rates have increased in each proceeding as documented in this response. The response to section B, that's what it reads, while base rates increased, EDIT amortization reduced the magnitude of those. Sure. The response to PSE 5.27 section B in this response reads, while base rates increased in each proceeding, the EDIT amortizations reduced the magnitude of those increases.
And just to confirm, those were black box settlements, correct?
Are you referring to a specific order?
Yes, so the settlements that were referenced in your rebuttal testimony that Veolia was a part of, Um, one of them was 23-0598. Um, the other was 19-0615. So let me rephrase the question. Both of the rate cases settled by Veolia after PSC docket number 17-1240. And those two rate cases were PSC docket 19-0651, I'm sorry, 0615, and PSC docket number 23-0598. Both of those were black box settlements. Is that correct?
I believe so.
Thank you. That's all I have.
DPA,
No questions, Your Honor.
Mr. Simon, do you want to mark this as an exhibit?
Yes, please. I believe it would be number 27, and I'd like to mark it for admission, Your Honor.
It would be 29.
29. I'm sorry, I can't read my own handwriting.
Okay. It's I'm going to mark PSC dash 5.27 as exhibit 29. Is there any objection from staff?
No objection.
DPA.
No objection.
Okay, I'm going to admit into evidence PSC dash 5.27, and it is entitled Application of Veolia Water Delaware Inc. for a general increase in rates, docket number 25-0037. That it's exhibit 29.
Your Honor, I have nothing further for Ms. Jacob.
Okay, thank you. Call your next witness.
Can I just take a minute to confer with Ms. Workman?
Sure.
Thank you. Your Honor, the company calls Dan Nemmer. Mr. Nemmer's last name is N-E-M-R. May I approach, Your Honor?
Yes.
Good afternoon, Mr. Nemmer. How are you? Can you tell me the document I just handed you? And did you prepare that rebuttal testimony yourself? If I asked you all of the same questions in that rebuttal testimony this afternoon, would your answers to any of those questions change? No. Do you have any corrections for your rebuttal testimony? I do not. At this point, Your Honor, I would like to mark Mr. Nemmer's rebuttal testimony as Exhibit 30 and move for admission into evidence.
Any objections, staff?
No objection.
EPA?
No objections.
Okay, admitted as Exhibit 30 is the rebuttal testimony of Daniel Nimmer.
I have no further questions for Mr. Nemmer on direct.
Cross, staff?
In lieu of cross, the parties have talked about admitting into evidence Mr. Nemmer's discovery responses to staff, and those are discovery responses to PSC 5.1 through PSC 5.25. And I have a copy for the reporter and the hearing examiner. I had sent it previously to counsel, and like I said, I stipulated to this with Mr. Simon, but I would like to give Mr. Crumpler an opportunity to object.
EPA?
No objections.
No objection.
So if it's okay with Your Honor, I would like to move, well, it depends how Your Honor wants to do it. Would you like to move PSC 5.1 through 5.25 as one exhibit, or?
As one composite exhibit, as it would be Exhibit 31.
Okay, well, I would like to move that into evidence.
Since there's no objection from any party, it's admitted as Exhibit 31.
No further.
So I assume Mr. Nimmer can be excused now.
Yes.
Okay, thank you.
Your Honor, if I may, can I request a brief bathroom break?
Yes. Okay, so it's 11:48. I'm sorry, 1:48. Let's be back at 2 o'clock. At 3. At 2 o'clock. Yep. Will the company please call its next witness?
Yes, Your Honor. Just a quick housekeeping question. We have two witnesses who we believe, and this hasn't changed, but that staff and DPA don't have any questions for and are willing to submit their testimony into the record. So would you like to handle that now or at the conclusion of our case, Your Honor?
Let's handle that now.
Yes, Your Honor. May I approach?
Yes.
Your Honor, at this time, the company would like to move into evidence as exhibit, it would be, I believe, 32, and the direct testimony of Catherine Arp, and as exhibit 33, the rebuttal testimony of Catherine Arp.
Any objections, staff?
No objection.
EPA?
No objections.
Okay, admitted as Exhibit 32 is the direct testimony of Catherine Arp, and admitted as Exhibit 33 is the rebuttal testimony of Catherine Arp.
Thank you, Your Honor. And then next, we would like to move into admission as exhibit 34, the direct testimony of Lino Bucci, and as Exhibit 35, the rebuttal testimony of Lino Bucci.
Any objections, staff?
No objections.
DPA?
No objections, Your Honor.
Admitted into evidence as Exhibit 34 is the direct testimony of Lino, Lino, Bucci, Bucci, and admitted into evidence is the rebuttal testimony of Lino Bucci. So that takes care of that. Are you prepared to call your next witness?
Yes, Your Honor, we'd like to call Jana Labella, Labella. May I approach, Your Honor?
Yes.
Good afternoon, Ms. Labella. How are you? I've just handed you two documents. Can you tell us what they are, please?
One is my direct testimony, and the other one is my rebuttal testimony.
With respect to your direct testimony, did you prepare that document?
Yes, I did.
And if I asked you the same questions that are in your direct testimony today, would any of your answers change?
No.
Do you have any corrections to your direct testimony?
I don't.
Your Honor, at this time, I'd like to move for admission of Ms. Labella's direct testimony as exhibit number 36.
And her rebuttal is 37.
Yeah, well, yes, Your Honor.
Any objections, staff?
No objections.
DPA?
No objections.
Okay. Ms. Labella's direct testimony is admitted into evidence as Exhibit 36, and her rebuttal testimony is admitted into evidence as Exhibit 37.
Ms. Labella, with respect to your rebuttal testimony, did you prepare that document?
Yes, I did.
If I asked you the same questions in that document today, would your answers be the same?
Yes.
Do you have any corrections to that document?
No, I don't have.
Okay, thank you. I don't have any further questions for Ms. Labella on direct.
Cross staff?
Yes. May I take a moment to get my papers together? Thank you. Are you ready, Ms. LaBella?
Yes, I am.
Waited right until you were about to take a drink. Sorry about that. On page 31 of your rebuttal testimony, looking at lines 20 through 21, you state,
21?
yes, 20 through 21, you state the company has been forced to revise the originally filed rate case expense amount from $278,000 to $1,255,500. Is that correct?
Yes, that's what it says.
Would you agree that it takes considerable time and expense for the parties to sort through testimony, discovery responses, scheduled exhibits, et cetera, that are inherent to a rate case?
Objections, compound question.
Would you agree that it takes considerable time and expense for the parties to sort through all the documents shared between the parties that are inherent to a rate case?
It depends on the scope of the issues.
So, for example, this case, the scope of the issues, the discovery shared, the MFRs, would you agree that it takes considerable time and expense for the parties to adequately look at those and prepare for testimonies and such?
When say yes, but then the scope of issues that were raised and items that were challenged by staff in their direct testimonies, I think that's what added and I guess additional time that needed to be spent on this rate case.
Ms. Well, could you speak into the microphone a little
sorry.
bit more? No, you're good.
Sure.
And would you agree that the parties should do their best to establish their positions in a manner that is clear and concise?
Yes, I agree with that.
The test period in this case ended in June of 2025. Is that correct?
Yes, that's correct.
And during the test period, the company did not provide quarterly updates to staff of actual test period data. Is that correct?
No, that's not correct. We did provide that.
You provided quarterly updates to staff of the actual test period data every quarter?
Yes, we did.
Objection. Can we, this, I believe, is subject to the settlement agreement we discussed.
So in this context, we're using it regarding rate case expenses.
Your Honor, can we go off the record for a minute and I can confer with Ms. Workman?
Let's go off the record.
At the bottom of the stack of papers that I gave you, there is one individual sheet. It's a printout from Excel.
MFR?
Yes.
Okay.
It is MFR 3.1. That is the statement of operating income and proposed revenue requirements that are attached work papers from Excel. And for your honor, because this is a Excel spreadsheet that I'm referencing, I made sure to send it ahead of time to the parties because we've only printed out one of the sheets and it is one of very many. And this is also mentioned in your rebuttal as Exhibit JL-4. But for purposes of today, I'm going to be referring to it as MFR 3.1. Is that okay? So just taking a look at that document, the MFR 3.1, do you recognize that document?
Yes.
To the best of your knowledge, does it seem true and correct?
Yeah.
Your Honor, I'd like to ask that this be marked for identification as an exhibit.
Okay, is there any objection from DPA?
No, Your Honor.
Any objection from the company?
No, Your Honor.
Okay, I'm going to mark as Exhibit 38 the Veolia Water Delaware minimum filing requirements of the Delaware Public Service Commission, statement of operating income and proposed revenue requirements, quarterly updates per books, and that is Exhibit 38.
Go ahead and take a minute to look at the document in front of you and let me know when you're ready to proceed.
Yes, I'm ready.
If you look at line number 17, that says revenue deficiency, correct?
Yes, I see.
And then in the as filed column, the revenue deficiency is listed as 15.9 million, correct?
Yes.
And then just to the left of the as filed column, it's the actual 12M 6/30/2025. You see that?
Yes, I see it.
And the revenue deficiency on line 17 there is 5.961, well, 5.9 million. Is that correct?
Yes, that's correct.
So the actual 12 months period that ended 6/30/2025, which was our test period, shows a revenue deficiency of 5.9 million. Is that correct?
That's actual information per books.
Is that
Yes, that's
correct?
correct.
Okay.
5.9 million. Yep.
And the company had internal figures to support a lower revenue deficiency from the test period that ended June of 2025 at the end of the test period, correct?
Can you repeat your question, please?
Yes. So the company had the internal figures to support a lower revenue deficiency from the test period that ended in June of 2025 at the end of that test period. Is that correct?
Well, this number represents a test revenue deficiency based on the actual numbers.
And they had
No
those,
adjustments.
yeah, and they had those numbers at the end of the test period,
Right.
correct?
We had these numbers. We provided it after June 30th, 2025, once the books were closed.
Okay, and the company did not modify their original request of a $15.9 million revenue deficiency until rebuttal testimony in November of 2025. Is that correct?
That's correct.
All else equal, do you believe additional time spent toward efforts to resolve a rate case likely leads to a higher or lower cost associated with that rate case?
Well, more time you spend, obviously more invoices will come in. And more invoices will come in from parties that are involved, that are charging the expenses to rate case expenses,
So it will,
including internal and external.
so that would increase the rate
Right.
case expenses.
Right, that's correct.
So in your statement, in your rebuttal testimony that we read at the beginning, you used the word, quote, that the company has been, quote, been forced, unquote. Is that correct?
Yes, that's what it says.
Did staff and the DPA force the company to wait 4 months until rebuttal testimony to reduce the company's request for a revenue increase?
Are you referring to the quarterly updates?
No,
Are you referring to the quarterly updates?
I'm referring to the statement that you
Rebuttal.
had made earlier that the request for in the revenue deficiency was not updated until November of 2025 when the rebuttal testimony was turned in.
Right, we have a procedural schedule. So per procedural schedule, we submitted the quarterly updates per books. After that, staff filed their direct testimonies. Then we had settlement meetings. And since there was no agreement reached during those settlement meetings, we filed the rebuttal testimony on November 4th.
Thank you. In front of you, you should have Ava Azad's testimony. And for everyone else in the room, I did not provide a copy. If you would like one, let me know. I've submitted this several times, so if you need another copy, just let me know. I have one available, but okay. Are you good, Gloria?
You said Ava Azad's testimony? Okay.
Yes, Ava Azad. So, Ms. Labella, looking at Ava Azad's testimony, not including her resume, her testimony is 11 pages long. Is that correct?
Yes, that's correct.
And in response to Ava Azad's testimony, the company provided rebuttal testimony from 4 different witnesses. Is that correct?
Who do you mean?
So the company had 4 witnesses respond to Ava Azad's testimony. And though I can name the witnesses.
Yes, that would be great if you could do that.
Gayla Fetcher, Larry Finicum, James Cosgrove, and Craig Murray all responded to Ava Azad's testimony. Is that correct?
Yes, they all had, references to Ava's testimony.
3 of those witnesses, Gayla Fetcher, James Cosgrove, and Craig Murray, did not provide testimony until rebuttal testimony, correct?
With the exception of Gayla Fetcher, she adopted Emily Gillen's testimony.
So she adopted testimony that was previously filed, but she herself had not filed previous testimony.
That's correct.
And 2 of those witnesses, Craig Murray and James Cosgrove, are engineering consultants the company retained to provide rebuttal testimony. Is that correct?
Yes, that's correct.
And none of those 4 witnesses to rebut Ava Azad, and again, those are Craig Murray, James Cosgrove, Larry Finicum, and Gayla Fetcher, have any legal qualifications. Is that correct?
Yes, that's correct.
And in their rebuttal testimony, they spent a substantial amount of time discussing the regulatory framework in an attempt to rebut Ava Azad's 11 pages of testimony. Is that correct?
That's correct, but in addition to that, there were other items that were discussed in those testimonies, not just Ava Azad's testimony.
Isn't it true that the company has 5 different witnesses who address the PFAS plant? And those witnesses are Larry Finicum, Gayla Fetcher, Craig Murray, James Cosgrove, and Marianne Hatch.
Short answer, yes, but you also have to look at the impact that that topic have on the entire rate case. It's a major driver of this case. So by basically denying recovery of PFAS treatment plant, company had to provide additional information. So commission has complete and accurate record to make a decision.
And then the company had 6 different witnesses address the topic of out-of-test period PFAS O&M. And those witnesses are Larry Finicum, Gayla Fetcher, Craig Murray, James Cosgrove, Marianne Hatch, and one Jana Labella. Is that correct?
That's correct. And again, you have to look at the impact that the PFAS O&M cost will have on a company of this size, as witness Hatch described yesterday during her testimony while she was here on the stand.
And isn't it true the company had 3 different witnesses to address the TCJA? And those witnesses are Anup Jacob, Dan Nemmer, and Jana Labella.
That's correct, and that's due to the scope that was brought up by Ms. Ara Azad in her testimony, saying that all commission orders on TCGA were not followed by the company, and that's been 8 years. So with Ms. Azad's suggestion to issue a $2 million refund, again, it's a big amount for a company of this size. So we needed to have sufficient information to respond to everything that Ara Azad stated in her testimony. I believe she spent around 20 pages just on this topic. So we had to respond to every single claim that she did. She brought up a lot of orders from the past, not just Veolia, but other companies as well. So we had to look into everything and respond.
And isn't it true that staff has 1 witness to address the TCJA?
That's true.
And staff has 1 witness who lays out the regulatory framework, correct?
Regulatory framework for what?
For treatment of PFAS.
Yes, I believe so.
So from staff's 2 witnesses, the company, I guess staff had 4 witnesses. From staff's 4 witnesses, the company's response required 14 different witnesses. Is that correct?
I don't know an exact count of witnesses, but it sounds correct.
And isn't it true that many of the company's witnesses cross-reference other witnesses in their testimony?
That's true, given their different background. So engineers speak presenting their facts from engineering perspectives, accountant from accountant's perspective, tax expert from tax perspective, and rates experts from rates perspective.
In your rebuttal testimony, you reference exhibit LB-1. Is that correct?
On which page?
I have on page 14, 16, 19, 27, and 28.
Okay, so 14, 16, 27, and 28? Is that correct?
I'm sorry, what was your question?
Which pages? 14, 16?
27, well, there's 28. Let me go through them again. We got 28, 27, 19, 16, and 14.
Yes, I see it.
In front of you, you have a copy of Lino Bucci's rebuttal testimony. You have that?
Yes.
And if you look at page 13,
13?
yes, page 13, it says, does this conclude your rebuttal testimony? And he answers, yes, it does. Is that correct?
Yes.
And then the next 38 pages of testimony are his exhibits, correct?
Objection. It's not his testimony. It's an exhibit to the testimony.
So
I-
the next 38 pages are an exhibit to his testimony, correct?
I'm looking at it myself. It says Exhibit LB 1, page 1 of 38, and what's the question? It's an exhibit to his testimony. Um, he has 13 pages of testimony and an exhibit with 38 pages.
Yes, I'm just trying to get confirmation that there's 13 pages of testimony, 38 pages of exhibits.
Okay, so I'll overrule that, the objection.
I wasn't clear on what the question was, but now I withdraw my objection. So
Okay,
So just to confirm,
Yes.
13 pages of
Testimony.
testimony, 38 pages of the exhibit.
Yes.
And the subject of his testimony is operating revenues, correct?
Yes, that's correct.
And then his 38 pages of exhibits are all staff's responses to discovery requests. Is that correct?
Yes, that's correct. That's set 1 and set 2. Set 1 and set 2 of discovery requests from Veolia to staff.
Pages 2 through 38 of his exhibits are not referenced as in his testimony. Is that correct?
I would have to go through his testimony to confirm that.
Would you agree subject to check?
objection. Give her the time to check if she wants to confirmation, but
I'm happy to give her the time.
let's give her the time to go through it. His testimony is not that long. It's only 13 pages long.
That's correct.
And you reference this exhibit LB1 again. This is the exhibit LB1 that you reference in your rebuttal testimony, correct?
That's correct.
Your testimony is cross-referencing to an exhibit submitted with Lino Bucci's testimony, correct?
That's correct.
When looking at Mr. Bucci's rebuttal testimony, in the 38-page exhibit we were just talking about, and where most of those exhibits he does not reference in his testimony, how is staff supposed to reach the conclusion that Exhibit LB1 goes with your testimony?
It has headers. Each exhibit had a name when it was submitted.
You see how having many cross references like that could add complexity and extra time for staff to sift through and review?
We did not want to submit exhibits multiple times. So that's why decision was made to submit staff responses in one exhibit and for other witnesses. We decided to submit staff responses in one exhibit and for other witnesses to reference to that exhibit.
We talk about financial stewardship grounded in rate affordability. Wouldn't it be relevant to consider how this rate case would require fewer resources to resolve if the filings weren't so convoluted and redundant?
Well, from our perspective, if you're referencing just the exhibit attached to Lena Bucci's testimony as a convoluted, it wasn't to us. We're trying to avoid that, and our purpose was complete opposite. We didn't want to submit a lot of individual exhibits. That's why we try to combine as many exhibits as possible. You probably noticed that there are some other exhibits that have multiple responses to staff's data requests combined as well. And in cases when multiple witnesses reference the same response, we attached it once.
Ms. Lobello, relating to the operations and maintenance line items to Veolia's amortization of tank painting and amortization of lagoon cleaning, were those two lines paid prior to the start of Veolia's test period?
Tank painting was paid in 2010, give or take. I might be wrong. It might be in 2009, but it was included in 2010 docket. It was a settled case. It wasn't specifically disallowed. And the rates that were approved by commission in that case were developed based on the revenue requirement that included that tank painting amortization. Every rate case since then included tank painting amortization. So it's been 15 years. That amortization is over 17 years, so it's going to end in maybe 2.5 years or so. It was never brought up in this context that we basically that we've seen in Ms. Azad's testimony, that position where previously approved amortization was called out of period, a retrospective rate making adjustment that was never approved because it was a black box settlement. In fact, in 2023 case, in docket 230598, both staff and DPA witnesses accepted in their direct testimonies both amortizations, tank painting and lagoon cleaning. And I'll talk about lagoon cleaning separately after tank painting. So these two items were not even discussed during settlement. And I understand that black box, the settlement in case 230598 ended up being a black box where commission and parties did not, commission did not make item-specific findings. It was a total amount that was approved. But again, base rates that were approved in that case were developed based on the revenue requirement that included tank painting amortization. And again, both staff and DPA didn't explicitly accepted it in their direct testimonies. When it comes to lagoon cleaning, that was done in 2019, I believe. No, I'm sorry. That was done in 2023 rate case. So amortization proposed at that time was 5 years. And since it was explicitly approved in the direct testimonies of both staff and DPA, we're currently amortizing it, and we did include that in the current rate case.
So just to be clear, those two items, the tank painting and the lagoon cleaning, they were paid prior to the start of this rate case's test period.
That's correct.
Thank you.
And just to clarify, tank paintings are done every 15 to 20 years. And it's very normal for our water utilities, and I'm sure other gas utilities do that as well, to recover a cost of tank painting over the useful life of that, of the service, basically, that was done, of the improvement. Not in the base rate case that sets rates for over 2 or 3 year period, because again, I know in staff's and DPA's testimony, I'm pretty sure in staff's testimony, that issue of the intergenerational inequity was brought up, right, as a concern. So if we look at it from this perspective, the tank paintings cannot be recovered over 2 or 3 years because the useful life is 15 to 20 years. And other utilities, water utilities in Delaware, they do amortize the tank painting expense over a number of years.
On page 16 of your rebuttal testimony, on lines 3 through 10, you discuss Ara Azad's recommendation regarding the amortization of lagoon costs. Is that correct?
Which pages? Which lines?
3 through 10. So that's page 16, lines 3 through 10.
So Ms. Azad is, I'm explaining what she stated in her response to Veolia Staff 4.
Okay.
That's Staff 4, that's a data request, Veolia Staff 4.
And that, in your testimony, you say, quote Miss Ara Azad. You say, quote, in response, my apologies. Starting at line 3, you say, furthermore, in response to data request Veolia Staff 4, see Exhibit 3LB1, witness Azad stated, to the extent opinions or views were expressed or issues were raised in the pre-filed testimony that are not specifically addressed in this settlement agreement, no findings, recommendations, or positions with respect to such opinions, views, or issues should be implied or inferred. This interpretation is incorrect, end quote. Is that what you stated in your testimony?
Well, there's more to that. After this sentence, I said the company is not implying or inferring staff's position. Ms. Marshall's position was explicitly stated in the pre-filed testimony. The company is simply referencing a staff position that was clearly presented on the record in docket 230598. And again, I'm presenting my position from the perspective of a rate expert. I'm not a lawyer, just to clarify.
Yes, I understand. Thank you. On page 16 of your rebuttal testimony, lines 19 through 23, you state, quote, as discussed in company witness Jacob's rebuttal testimony, it would be unreasonable for the commission to take the position that in the context of a black box settlement, any issue that was explicitly addressed and agreed to in sworn testimony, but not explicitly memorialized in the settlement agreement, would remain open for adjudication indefinitely. We do not believe this is a policy position the commission intends to adopt through this rate case, end quote. Is that your statement? Correct?
Yes.
Do you believe it is appropriate for Veolia to speak for the commission's intentions?
Objection, mischaracterizing her testimony.
Do you believe it's appropriate for Veolia to infer the commission's intentions?
Objection, still mischaracterizing her testimony.
Ruled.
Just express my opinion. I don't think I suggested anything. I just said that the position that was taken in Mrs. Out's testimony, that anything, if the case was settled through a black box, that anything that was included was not approved, basically.
But you explicitly say that this is not a policy position the commission intends to adopt.
Yes, I just said I do not believe that this is what commission intends to adopt through this rate case. Yeah.
Do you speak for the commission?
No, I'm only expressing my point of view, that I did not believe that this is what commission was trying to do.
And where you
Would do.
say, oh, I'm sorry, I didn't mean to cut you off.
I'm done.
Okay. And where you say, quote, would remain open for adjudication indefinitely. To be clear, those are your words, not Ara Azad's words, correct?
Correct. But Ara Azad's words were that since tank painting, for example, was settled through a black box, that means it wasn't approved. And in that case, it cannot be used or included in any case after that. Because as we discussed, that tank painting was done in 2010. So I don't remember which case was after that. So let's say if next rate case was in 2013 or in 2015, that would be out of period adjustment or something that did not happen in the test period. So what we were trying to get to understand in our rebuttal, well, no, I'm sorry, not rebuttal, in our discovery to staff is staff's position on recovery of tank painting cost in general. For example, if company needs to do a tank painting in 3 years, how would we recover this cost? What was staff's position on that? And we did not get any answer. And as explained before, we cannot recover tank painting cost if it happens, for example, in the test period actuals, if it's included, we cannot recover it over 2 or 3 years because we'll basically make the certain group of ratepayers pay for something that others will use in the future and will not pay for that.
Going back to the exhibit LB1, which is attached to Lino Bucci's testimony, I'm looking at page 4. So that's exhibit LB1, page 4. The first paragraph in that question says, on page 7, lines 17 through 26, and page 8, lines 1 through 18 of Ms. Azad's testimony, a summary of the results of Veolia's most recent prior rate case, docket number 23-0598, is provided. In preparing this summary, did Ms. Azad review the testimony of staff in that proceeding? Is that correct?
Yes, that's what it says.
And then the last paragraph of that section, that question, the company asked, if no, please explain how this new information, which is Ms. Marshall's quoted statement from docket number 23-0598, impacts your position on this issue and by what dollar amount. Is that correct?
Yes, that's correct.
And in response, Ara Azad responded that Ms. Azad is familiar with staff's testimony in docket number 23-0598, as stated on lines 1 through 18 on page 8 of the direct testimony of Ara Azad, as is often customary in the settlement agreement approved in docket number 23-0598. The parties stipulated and the commission approved that, quote, no party to this settlement agreement necessarily agrees or disagrees with the treatment of any particular item, any procedure followed, any calculation made, or the resolution of any particular issue. Is that correct?
That's what it says.
And on the next page, page 5, Ms. Azad continued, quote, to the extent opinions or views were expressed or issues were raised in the pre-filed testimony that are not specifically addressed in this settlement agreement, no findings, recommendations, or positions with respect to such opinions, views, or issues should be implied or inferred. Is that correct?
That's correct. And that's exactly what I was talking about, that Ms. Azad stated in her in her direct testimonies in regards to recovery of tank painting costs. Because tank painting costs, the lagoon cleaning costs, have to be recovered over its useful life. If parties agrees, and there's a settlement agreement that doesn't specify every single item that's included in the cost of service, my understanding is, and again, as a rate professional, that everything is approved unless it's specifically disallowed.
Thank you, Ms. LaBelle. I have no further questions.
DPA?
Yes, Your Honor. May I approach the witness?
Yes.
Your Honor, before we continue, can I verify that it was the statement of operating income and proposed revenue requirements was moved into evidence?
It, it was as 38.
Thank you. I didn't want to leave it as just marked. I wanted to make sure it was moved. Thank you, Your Honor.
That's the last exhibit. So the next exhibit, the 39. I don't know what EPA is going to do here.
Okay. You ready, ma'am?
Yes.
Okay. Most of my questions are going to be sort of clarifying questions. Do you have a copy of Ms. Arp's testimony in front of you?
Yes, I do.
Okay, and if you could go to,
Speak into the
yeah,
microphone.
sorry, if you could go to page 4 for a rebuttal testimony,
Yes, I'm on page 4.
and looking at specifically lines 18 through 21. Let me know when you're there. You there, ma'am?
Yes, I am.
So she indicates that the company has accepted Mr. Watkins' adjustments to CIAC, accumulated depreciation, accumulated deferred and unamortized income taxes, and investment credit, and OPED funding amounts, correct?
Yes, that's what it says.
Okay. All right, then skipping ahead 2 pages to page 6, looking at specifically lines 8 through 10. Let me know when you're there.
I'm here.
Okay. The company does not accept Mr. Watkins' adjustments to cash working capital, correct?
Yes, that's what it says.
Okay. All right. And the company's disagreement with Mr. Watkins' cash working capital adjustment, it's based on the company witness McDougal, correct? Who we heard from this morning, I believe?
Yes, that's correct.
Okay. All right. Now, skipping ahead 2 more pages to page 8, specifically lines 4 through 11. Let me know when you're there, ma'am.
Yes, I'm here.
Okay. So she discusses Mr. Watkins' treatment of excess deferred income taxes, which I believe the company refers to as TCJA, also known as Tax Cuts and Job Acts. And on line 11, Ms. Arp indicates the company agrees with DPA's proposed adjustment. Is that accurate?
That's what it says. Yeah.
Okay. And ma'am, I believe I gave you a copy of Mr. Watkins' direct testimony. Okay.
I have it here.
And have you read over Mr. Watkins' testimony?
Yes, I did.
Okay. And can you tell me anywhere in Mr. Watkins that he makes an adjustment to EDIT or even mentions EDIT in his testimony?
It is not in his testimony, but it is on the schedule GAW 25.
And would you agree, is it fair to say that Mr. Watkins silence on this issue is an indication that he did not investigate EDIT?
Objection, speculation.
Sustain.
Okay. Ma'am, does Mr. Watkins say anywhere in his testimony that he accepts the company's calculation of excess deferred income taxes?
It is not in his testimony. He doesn't talk about it, but in Schedule GAW, DPA recommended amount is the same as per books actuals.
So he never talked about it.
No.
Okay, thank you. Now, moving ahead, ma'am, off of Mr. Watkins' testimony specifically, I want to talk about chemicals expense. If we may separate the cost between I'll refer to as traditional chemical costs and PFAS media expenses. With regard to traditional chemical expenses, am I correct that you accept Mr. Watkins' adjustments as set forth on page 5 of your rebuttal testimony?
I believe that's correct, but I'm going to check.
You take your time, ma'am, if you need to double check that.
Yes, that's what I said. I accepted DPA's traditional chemical expense.
And associated with PFAS media expenses, I believe there are two components. The actual expenses associated with replacing media, as well as the freight associated with disposing of the media, correct?
Not the actual. These are estimated chemical expenses for media itself, and then in outside, that was included in the chemicals. And in outside services, we had a freight in and out related to media expense.
Okay. Fair enough. In the company's as filed case, it was estimated that the replacement cost of media to be 4.167 million, and the cost of freight to transport such media 0.916 million, for a total of 5.083 million, correct?
That sounds correct. I don't have my direct testimony. Hold on. Maybe I do. I don't know.
Ma'am, I'm going to flip to one other document. Do you have Mr. Fetcher's testimony in front of you? Miss, my apologies.
1 second. Let me just
Take
check
your
my
time.
testimony first, and then just to verify the numbers. So it was 4.1 for the PFAS chemicals for the media, and then for outside services, you said 0.9, right?
Yeah.
Okay.
Okay. And then going over to Ms. Fetcher's testimony, specifically looking at pages 65, lines 9 through table 8. Yeah, that's rebuttal. My apologies.
Page 65.
65.
Yes, I'm on page 65.
And going on through the table on the other page 66. Just to clarify, the company has updated its estimates of PFAS O&M expenses, correct?
Yes, that's correct.
And that was set forth in Ms. Fetcher's rebuttal, table 8.
I don't have I'm sorry. Yeah, table 8, Ms. Fetchers, yeah.
And am I correct that the cost of the total PFAS media expense has been reduced from a little over 5 million to a little above 3.5 million, correct?
That's correct. And Ms. Fetcher explained yesterday why the estimates were reduced.
Okay. And are you aware if the company has yet incurred any other PFAS-related media expenses?
Related to change out?
Yeah.
No.
just double check one thing. Okay, and shifting gears slightly, one second, ma'am. Okay. Looking at your rebuttal testimony do you have a copy of that?
Yes, I do.
Okay. And towards the end of your rebuttal testimony, on pages 31, let me know when you're there.
I'm on page 31.
Okay. So on lines 13 through page 32, lines 3, you say you disagree with Mr. Watkins' recommended treatment of rate case expenses, correct?
That's correct.
Okay. And on the topic of rate case expenses, you characterize this as amortization versus normalization.
Which line is it on?
Well, I'm looking at specifically lines 14 and following. It says the company disagrees with the position of witness Azad and DPA witness Watkins regarding the amortization period for rate case expense.
Yes, I see it.
Give me one second.
Just to clarify, that's on page 31 of her rebuttal, right?
Yes. One second, ma'am. All right, ma'am, are you familiar with the commission's practice on whether our rate case expenses are normalized or amortized?
Well, normally, they're amortized over a specific period of time. When you say normalized, what do you mean by that?
Well, I don't, I'm just asking you the questions. I mean, what was your answer?
Well, normally we amortize it over a period of time. If it's a settled case, we usually discuss over what period of time we're going to amortize it.
Let me give you
That also depends on the timing of the next rate case, potential rate case.
Let me give you a hypothetical. So if you amortize rate case expenses over 5 years, but you had let's say another rate case in say 3 years, there would be 2 years remaining on the amortization of this rate case, which would then be pancaked along rate cases expenses in the next rate case, correct?
If that's included in the settlement as on the amortization section.
I know, but this
stating
is a
that-
hypothetical.
Well, I can't answer a hypothetical. Well, I mean, I can answer
Why
with the
not? Well,
I can answer with the hypothetical also, that if the settlement includes language allowing company to amortize cost over 5 years, allowing company to amortize cost, amortization, rate case expense, or to amortize rate case expense over 5 years, like in this example, then yes.
so have you ever seen the commission actually do that?
In other jurisdictions.
I'm talking about here in Delaware.
No, not in Delaware. Delaware usually has a black box settlement that doesn't include item-specific language.
Well, I understand that oftentimes cases settle, but we're in a case with litigation.
That's the first time I'm participating in the litigation.
Thank you, ma'am. No further questions at this time.
Redirect?
Yes, Your Honor. Ms. LaBella, do you remember speaking with Ms. Workman about the company's increase in the rate case expenses in this matter?
Yes, I do.
When did the rate case expenses increase in this proceeding?
We increased the rate case expenses in the rebuttal testimony.
And that was after staff's testimony was filed, correct?
That's correct.
Did this proceeding cost more than the company's, or has this proceeding cost more than the company's previous cases?
Yes.
Was the nature of staff's testimony in this proceeding different than the nature of staff's testimony in prior proceedings?
Yes, very different.
Can you briefly explain why?
Well, as we discussed certain items today, for example, amortization of tank painting, TCJA, lagoon cleaning, were disallowed by staff. That was their position. There were certain, there were a lot of discussion on the PFAS regulation. That is also, I understand that PFAS is a new topic, but it was a big part of the case as well. That's normally is outside of the scope, especially the regulation part. Yeah, and that's pretty much it. Yeah. There might be some other items. I'm not remembering.
I believe you stated earlier that the PFAS component of this proceeding was a major driver, correct?
Yes, that's correct.
And you mentioned the PFAS media change out just a moment ago. Does that also, the PFAS component also include the capital investment in the plant?
Can you repeat the question, please?
Sure. I'm trying to figure out if the part of the component of the company's seeking recovery for in this case is the capital investment in the Stanton Water Treatment Plant PFAS project.
Yes.
Do you recall Ms. Workman asking you why many of the company's witnesses cross-referenced other company witnesses?
Yes, I remember.
You reviewed Ms. Ara Azad's testimony in this case, right?
Yes, I did.
Did she cross-reference Ava Azad?
Yes, she did.
And you reviewed Ms. Ava Azad's testimony in this case, correct?
Yes, I did.
Does Ms. Ava Azad's testimony cross-reference Ms. Ara Azad?
I believe so, but I'm not sure. I think so.
You have Ms. Ava Azad's testimony in front of you?
Yes, I have it.
Please turn to page 4, lines 8 through 10, please.
Lines?
Page 4, lines 8 through 10. Read that and let me know when you're done, please.
Yes.
Does Ms. Ava Azad's testimony refer to the testimony of witness Ara Azad?
Yes, it does.
In your experience in utility rate proceedings, is it common for witnesses of one party to cross-reference other witnesses of one party?
Yes.
Do you recall speaking with Ms. Workman about the amortization of items like tank paintings and lagoon cleaning?
Yes, I remember.
If you don't spread the cost of items like tank paintings or lagoon cleaning over the life of that asset, can you tell me what is the effect of how to recover those costs from customers for the company?
Well, if we recover through base rates as an item of cost of service, as any item, as a purchase water or power, purchase power or sludge transportation, that would increase rates tremendously for the customers that will be paying rates for until the next base rate case. That means we will recover costs a lot faster than we would have recovered using amortization over a number of years.
Is there a term or a phrase for what happens when rates go up suddenly like that?
Rate shock?
And what would happen if the cost of item or the amortization of items like tank painting or lagoon cleaning were spread only over a year or two?
Rate shock?
I don't have any other questions. Thank you. Actually, I do have one more question. I'm sorry. I didn't scroll down far enough. When Mr. Crumpler asked you about accepting Mr. Watkins' adjustments to chemical expenses, that term chemical expenses, as the company's using it in this proceeding, does that include the PFAS media changeouts?
Not to traditional chemicals.
Thank you. I don't have any other questions. Thank you.
Staff?
Ms. Labella, do Ava Azad and Ara Azad testify to the same subject?
There were multiple subjects that they testified to.
But do they overlap the topics on which they provide testimony?
On PFAS?
On the regulatory portion?
Right, on PFAS testing.
Okay.
Also on the PFAS rate base.
Is it common for 3 to 6 witnesses to testify on the same topic?
Objection to form. Foundation.
Mr. Simon,
Sustain, I think, be more specific.
how many staff witnesses does Ara Azad reference in her testimony?
I believe only Ava Azad. I'm not sure if she refers to Joshua as well. I would have to review her testimony again.
So subject to check, you would say 1.
Yes, I would say so.
And how many staff witnesses does Ava Azad reference in her testimony?
Subject to check, 1, Ara Azad.
So to confirm what you just discussed with Mr. Simon, staff had 2 witnesses who cross-referenced each other's testimonies, correct?
Yes, that's correct.
And the company had 14 witnesses who cross-referenced each other. Is that correct?
That's correct. But I would like to add that the burden of proof, it lies on the company, and company needs to provide more information.
Thank you. That's all.
EPA?
No further questions.
Nothing further, Your Honor.
Okay, thank you. Could we go off the record for a second? Okay. Let's address the motion for reconsideration now. Miss Hatch is Exhibit 15. Which is the rebuttal testimony of Ann Hatch. Yeah, I have it.
You need a copy, Your Honor?
No, I have it.
Oh.
Who would you like to hear from, Your Honor?
It's the company's motion for reconsideration.
One moment. Thank you, Your Honor. As I mentioned this morning, the company is making a motion for reconsideration of Your Honor's decision to exclude certain portions of Ms. Hatch's rebuttal testimony concerning the PFAS O&M mechanism. Yes, I'm sorry. This company's motion for reconsideration is based on order number 8707 and docket number 14193, proceeding captioned in the matter of the application of Delmarva Power and Light Company, Exelon Corporation, Pepco Holdings, Inc., Purple Acquisition Corporation, Exelon Energy Delivery Company, LLC, and a new special purpose entity for approvals under the provisions of 26 Delaware Code, Sections 215 and 1016. It is a decision by Your Honor. In that proceeding, Your Honor denied a motion in limine to exclude portions of rebuttal testimony of a party that presented a new theory for the first time on rebuttal. In relevant part, Your Honor found, and I quote, "This commission has never distinguished as to which facts, arguments, or analysis must be included in direct and rebuttal testimony. The commission has never done this because it obviously wants to develop a complete evidentiary record in a constantly changing administrative case such as this, where the joint applicants must establish at the evidentiary hearings that this proposed merger is in accordance with law for a proper purpose and that the proposed merger is in the public interest," citing 26 Delaware Code sections 215D and 1016, end quote. That while the nature of that proceeding is different for approval of a merger, the legal rationale remains the same here, Your Honor. This is an administrative proceeding where the petitioner, the company, has the burden of proof. Therefore, the introduction of its evidence is critical, especially in a rapidly changing case. Your Honor continued in that order to indicate, in relevant part, the commission does not have a case-in-chief requirement requiring the petitioner to, quote-unquote, stick with their direct or deposition testimony. And in relevant part, relying on briefings submitted by the applicant in that case or the party resisting the motion in limine, Your Honor found, quote, "Delaware cases have uniformly held that if a party is given the opportunity for cross-examination of witnesses, a witness's evidence submitted in rebuttal will not be excluded," citing Tower View LLC versus Cox Radio Incorporated, 2013, Dell Chancery, Lexus 159, cited June 28, 2013. Your Honor's parenthetical also indicates that there are cases cited by the joint applicants. And Your Honor therefore denied the motion in limine and allowed the rebuttal testimony that espoused a new theory to be considered in the case. So for those reasons, Your Honor, I believe the decision you made yesterday was predicated on the fact that the nature of rebuttal testimony should not include new theories. However, the prior precedent by Your Honor, as well as Delaware law, the Tower View case and the other cases cited in Your Honor's decision and in those papers, demonstrates that Ms. Hatch's testimony here concerning the PFAS O&M mechanism should be admitted and considered. And certainly, we're happy to present Ms. Hatch for cross-examination on that to make sure that the parties have a full and fair opportunity to explore that theory and be heard. And as I mentioned this morning, we are also more than willing to permit staff, the DPA, to allow their witnesses to provide new testimony to respond to that in direct examination if they so choose. We simply want to make sure that there's a complete evidentiary record for the commission to make a decision on the changing evidence in this proceeding. So that concludes the company's motion to your honor.
Staff.
There are two important distinctions between the factual underpinnings of the case referenced versus here. Mr. Simon has presented the decision as allowing the admission of rebuttal testimony when a new method was introduced and it was allowed into evidence. But important to the hearing examiner's decision in that case was, and this is a quote, is that the parties, quote, persuasively argue that they have not employed a new approach. Rather, the joint applicant's synergy cost-saving analysis has evolved with more refined data, end quote. So an important distinction is that in that case, there was not a new approach. Instead, there was a refined approach, or there was a evolved approach. And that evolved approach was based on more refined data. In this case, Ms. Hatch's surcharge mechanism referenced in her rebuttal testimony is not an evolution based on refined data. There was not new data informing the decision to change the mechanism proposed. Instead, her surcharge mechanism is a new methodology produced in rebuttal as a response to staff and DPA's direct testimony. So it's not an evolution. It's not based on new data. Instead, it's a new method. The second distinction, which Mr. Simon has pointed out, is that this is a merger case, not a rate case. The standard in merger cases are governed by 26 Delaware Code 215. And a merger is a fairly low standard. All the applicant has to approve to get a merger is that the merger is, quote, is to be made in accordance with law for a proper purpose and is consistent with the public interest, end quote. That's a very low standard. Compare that to the standard that we're trying to apply here, which is that the commission needs to find just and reasonable rates evaluated in a business judgment standard. So those two standards are very different, and the consequences of the two actions are very different. One is going to potentially raise rates or change rates possibly significantly for, I believe Veolia has around 100,000 customers, versus a merger where one corporation is merging with another. And so I think in this case, it's particularly important to protect both the process and the possible outcome and the consequences that could flow from having to address this new methodology that was proposed by Ms. Hatch. So for those reasons, staff argues that Your Honor should uphold your previous hearing or your previous ruling and disallow that portion of Ms. Hatch's testimony. Thank you.
The only thing I'll add is I think it goes to the heart of what is the purpose of rebuttal testimony. It's to rebut the direct testimony of the staff or the DPA. It's not to come out with a new approach, and it's because it's just patently unfair. And I'll just echo what Ms. Workman just said in terms of there's a differentiation between rate cases and mergers, Your Honor.
May I briefly respond, Your Honor?
Yes.
Thank you. I just want to clarify something Ms. Workman said. She argued that she tried to distinguish the prior decision with this decision by saying that decision was based on refined data and circumstances. And that's exactly what we've had here. We've listened for the past 2 days to information about how the media change-out frequency at the plant has been revised based on the frequent collection of data by the company. That's one of the drivers behind the new theory in Mrs. Hatch's testimony. And second, as indicated in her testimony expressly, she is responding to the criticisms made by staff and DPA's witnesses. And so, to the extent that Mr. Crumpler raises a fairness argument, again, that's something the company is trying to alleviate here by presenting the opportunity for Ms. Hatch to be examined on cross, as well as to have their own witnesses respond should they choose to do so on direct, which we will not take any opposition to. So that's all I'd like to say. Thank you.
In the case that you cited, which involved the merger, Exelon and Delmarva Power and Light, what happened was when they were integrating those two companies, okay, what I wrote here was that there were estimates they were of employee attrition, people leaving the company, and also detailed information about integrating the computer systems. So there were synergies involved between these companies. I want to point out another thing, which was handed to me, and it's not an exhibit yet. In James Cagle's April 2023 testimony, which, the prior rate case, he had proposed this rate mitigation mechanism, which was rejected. And that was back April 2023. It was not proposed originally by the company here in the direct testimony.
Mr. Cagle did produce direct testimony in this case. He renewed that request for a mechanism. Staff and DPA responded to that request. One moment, Your Honor. I apologize, Your Honor. I misspoke. In the 23 case, Mr. Cagle proposed a surcharge mechanism to begin recovery of capital expenses. The mechanism in this case deals with the PFAS O&M costs.
Okay, but in the direct testimony, there was no mechanism proposed in this case, right?
For O&M costs?
For either capital costs or O&M costs.
In Mr. Cagle's direct testimony, which has been adopted by Ms. Hatch, she did propose a mechanism for the recovery of PFAS O&M costs. That's correct.
For both. But
just O&M costs, Your Honor.
Just O&M?
Yes.
Okay. And so this new mechanism that's in rebuttal, how does it differ? What are the specifics about it?
It is a disc-like mechanism, Your Honor.
Mm-hmm.
And so rather than forward-looking recovery of the cost, the company would essentially pay the cost of the PFAS media change-outs, and then on a semi-annual basis, or it's up to debate, would come before the commission and seek recovery of those costs it already expended to give the commission and DPA a chance to evaluate those costs. So it would be more of closer to real-time recovery as possible rather than forward-looking recovery of those costs.
And would this be on a semi-annual basis? How often would this occur?
Semi-annual, Your Honor. And the proposal would include it would be reevaluated in the company's next base rate case to determine if it was still necessary.
Staff, do you have anything to add?
If you give me just a moment, I'm trying to look at Mr. Cagle's testimony just real quick in this case.
It's number 14.
Your Honor, in Mr. Cagle's testimony, it is not a surcharge that he is proposing. He is proposing, and this is, I'm looking at his testimony in this case, which was adopted by Marianne Hatch. I'm looking at page 5. They're proposing the inclusion of O&M expenses in the current case on a deferred basis, subject to true-up for inclusion in the company's next base rate case filing. So that is not a surcharge as proposed. That is or as proposed in rebuttal by Ms. Hatch. It is instead a reg asset.
It's a reg asset.
And
Right.
a surcharge is significantly different than a reg asset.
And as indicated in Ms. Hatch's testimony, that revision was to respond to the concerns identified by staff and DPA.
Well, on page 5 of Mr. Cagle's testimony, it says, with the proposed mechanism, the company would record a regulatory liability for the amount of PFAS media costs included in base rates from the time the rates go into effect in this case. Once the company incurs expenses related to the media exchange, the regulatory liability would be reduced by that amount accordingly. The remaining balance of the regulatory liability would be included for resolution in the company's next base rate case filing. Additionally, the company proposes to submit a report on semi-annual basis detailing the activity and balances of the regulatory liability. So that's what he was proposing. And so what was Ms. Hatch's, how does her proposal differ from that?
May I refer to her testimony, Your Honor?
I noted in Ms. Hatch's testimony that I believe that this mechanism only applies if the company's not compensated for the operating costs. Is that true?
I'm sorry, Your Honor, can you repeat that?
That the mechanism would only apply if the company's not compensated for the operating costs.
That's correct. Yes.
So it's really a fallback position.
That's correct.
Okay. So how does the mechanism work?
So it's essentially, as detailed on page 27 of Ms. Hatch's rebuttal testimony, the PFAS media changeout costs, which include media and freight, would be charged to a deferral account. No interest would accrue to the deferral account. A deferred accounting treatment would be requested for the specific PFAS O&M expenses. Thereafter, at 6-month intervals, after the implementation of new rates, the company would submit a filing for a surcharge. Staff and the DPA would have 30 days to review the filing for prudence before it became effective. If no costs were incurred during that 6-month period, the company would issue a notification letter to staff and DPA. The surcharge would be applied to the total bill amount, excluding the DISC surcharge. At the end of each 6-month period, the company would reconcile the difference between actual cost and what has been recovered in rates and include the variance in the following surcharge, with interest accrued on over recovery only. For example, the over/under recovery from the first filing would be included in the third filing.
Okay, so now I'm clear on it.
Okay.
The merger case was a different case from rate cases. It was a different case than I've I've handled all the time that I've been here. Um, I'm going to change my ruling, and I'm going to allow the company to present this mechanism. And the reason I'm doing, first of all, I think that it should have been presented in direct testimony, but nevertheless, I'm doing it for one reason, is that the commissioners are appointed by the governor, and they have a right to see it. And even if it's presented as an alternative position, I believe that they have the right to see it. I don't like rebuttal positions like this. But nevertheless, PFAS are a major issue in this state. And it's a very costly issue. And I'm not sure how the commissioners are going to decide this. And so I think the wise decision, as opposed to focusing on technical rules like the scope of rebuttal testimony, I think the better decision is to allow the commissioners to have the opportunity to see the mechanism and allow them to make the final decision about it.
Thank you, Your Honor.
Okay, so is Ms. Hatch going to testify about this?
She's prepared to testify.
Okay.
Yes, Your Honor.
Okay, so let's have her.
Your Honor, we are not prepared to cross-examine her today.
Okay, Miss.
Your Honor, now that you've changed your ruling, staff would like to request an opportunity to respond to the surcharge mechanism, as there was no rebuttal that happened. So staff and the DPA have not yet had an opportunity to address this and are not prepared to address this by Monday, when likely our witnesses would need to address it. So staff would request that we be given a certain amount of time to respond in writing to the proposal of Ms. Hatch.
How much time? I mean, before you answer, I can keep the record open, and we could, hold a hearing in the future by Zoom. And you file something in writing, and then we hold a hearing with Ms. Hatch by Zoom. And, once this hearing gets concluded, in the future, you file something in writing, and then we hold a very short hearing on this issue. Because I realize it's an important issue, and I don't particularly like the way that this has been done at all. But then again, the commissioners make the final decision here. So,
How long would you be willing to give us?
I think the question is you all have to decide, what your workloads are like, and propose something to me.
So would you like us to try and work this out and then bring you something on Monday, perhaps, for like a time limit?
Monday or Tuesday.
Okay.
Okay.
So by Monday or Tuesday, there'll be a time frame about when.
Just a proposal of a
Schedule.
time frame, and then we can look at our calendars and try to figure something out.
Okay.
So just to be clear, we need a time frame for staff to file, I guess, rebuttal on
Yes.
this one issue. Would the company need time to respond to that?
We would appreciate that.
Yes, the company can respond to it.
And then we would have a hearing.
Then we would have a hearing where Ms. Hatch would testify, just like she would here.
And would the DPA and staff's witnesses also be expected to testify at that mini hearing?
Yes.
Okay. Thank you. I'm clear on our procedure, what we're shooting for. Thank you.
Okay. And it would, I know everybody is busy, but it'd be better if it occurred in the near future, just so that the record can be closed.
Your Honor, and what you just mentioned, staff and the DPAs, so our witnesses are working on filing artesian testimony, I think due next Friday. So it's obviously something that we can address on Tuesday. Our witnesses are pretty jammed up, obviously,
Right.
We'll work it out.
but we will work it out.
We are completely understanding of that. And, we're happy to be flexible. Not expecting something by next Friday. I know Your Honor would like to move this, but certainly we don't want to inconvenience anybody.
Well, I don't think it's going to happen that quick.
I agree. I agree.
Okay. So, all of us will work that out one way or another. And so, I think we're done for today. right?
Yes, subject to what we just discussed. The company doesn't have any other witnesses.
Sounds like a Monday problem.
Mr. Ferguson, you were going to send me the Azad testimony redactions, I believe, in advance of Monday.
Yes, I will.
Okay, thank you. And then
Is any party circulating an written exhibit list? Okay, thank you. Okay.
with respect to exhibits, would Your Honor prefer that I move in the company's application and the relevant public notices at this point in time, or at the conclusion of the entire case?
Let's do it at the conclusion of the case.
Yes, Your
because we may pick up a few things in the meantime, a few additional exhibits in the meantime.
Then we have nothing further for today, Your Honor.
Okay. Okay. Thanks, everybody. And I'll adjourn today, and we'll start again at 9:30 on Monday. And everybody have a nice weekend. Thanks.
Thank you, Your Honor.